So my apology for the delayed start. May I invite a volunteer member to say prayers?
Let us pray.
Okay, she's here.
Very well.
Dear Lord and Heavenly Father, as we are gathered here this morning to do the business of this Parliament, we seek your blessings and your guidance. Lord, we thank you for all you have bestowed on us as individuals and as a country. We continue to ask your mercy and your grace as we move forward. In your name we pray. Amen.
Thank you, Member Senator Campbell Rodriguez.
I'm sorry?
Do we have any apology for absence?
No apologies. Chairman,
Yes.
they have a concern. They're not.
Madam
check.
Chair.
I gather I'm not being heard clearly. Is that better now? Thank you.
I'm hearing you, Madam Chair.
Yes. Member Campbell Rodriguez.
I'm hearing you.
All right, we have no apology for absence.
Madam Chair,
Yes.
no apology for absence here, but Member Williams, Donovan Williams, asked me to apologize. He's running a few minutes late, but he's on his way.
Thank you.
They weren't advised.
All right. Let me welcome everyone to the resumption of this hybrid meeting of the Joint Select Committee appointed to consider and report on the bill entitled An Act to Repeal and Replace the Bail Act and to provide for connected matters. As anticipated when we last met on Tuesday, our meeting for yesterday would have been cancelled to enable the meeting of the PAAC to take place to deal with the second supplementary estimate. As I look at the pace of work that we do in the Parliament, I cannot help but lament how badly we're affected by the paucity of resources and the fact that we do not really have enough space to do the work of the Parliament. And once the chambers is occupied, nobody else can be in here because it can only deal with one set of proceedings at a time. Nonetheless, we will prod along until the situation is improved. Between last meeting and today, members should have received the promised clause-by-clause overview document from the Ministry of Legal and Constitutional Affairs. And I believe all of the presentations for today have been circulated. I noticed that the minutes of the last meeting are not noted for confirmation for today. Meetings of the last meeting is a standard agenda item. I'm not so sure why it's omitted, but we take note of the omission. And it will mean that when we next meet, we will have two sets of minutes to deal with. I will ask that as soon as they are circulated, that members read them so we can take them. I do not want to have minutes of the meeting left for the last meeting. It is important that we deal with all of the administrative and procedural requirements as we go along, because we do have a timeline that we hope to meet for the enactment of this bill. On that note, I will move to new business, and new business really focuses on presentations. We will have 6 presentations today. In the interest of time, I am allocating 20 minutes to each presenter to enable interaction with members of the committee. It means, therefore, that presenters may not be able to read verbatim the report that has been submitted, but we certainly want to hear the critical points that you wish to make. Now, from what I'm seeing here in the chambers, those present are all attorneys. And so I have every reason to believe that the points to be made to the committee can be succinctly made without losing any of the substance. I'm also pleased to see that I'm being joined by members in person, including the Honorable Minister, Member Chuck, and the faithful members Charles and Williams in person. All right, so on that note, may I just check? I know we have the president of the Jamaican Bar Association. The Jam Bar is listed in 2nd place. Do we have a representative from the Faculty of Law, UWI? Not yet. And we have the Independent Jamaica Council on Human Rights present. I see our former public defender present with us in person. Very pleased to have you. And we see Mr. Clark present with us. I take it that you are here with the Independent Jamaica Council for Human Rights. Very well. All right, since the Faculty of Law, UWI, which is listed at first, is not here, we will move to the Jamaican Bar Association, represented by President Alexander Williams, who is no stranger to the Parliament. He has the experience as a legislator, having served as a senator some time ago. Mr. Williams, it's now 10:25 almost, 35:45. Please proceed with your presentation.
Thank you very much, Madam Chairperson, Minister, and thank you very much for this opportunity to present our comments and concerns on the bail bill of 2000. I'm going to do my very best to limit my presentation to 15 minutes. I have a strong feeling I won't be able to, because you speak about what we consider salient and key points, and I dare say the salient and key points is just about the entire submission that is already before the committee. Plus, don't mind telling you, there's an addendum. And I don't know if the
addendum has been brought to my attention, and I believe it has been circulated to members of the committee.
Very well. I do not propose to read through the entire thing, but I'm going to have to shadow it as I go along. So, we of course make reference to the right to bail, the background to the bill, and we make the first point that we do not consider a need to amend the Bail Act at all. Last Bail Act is in 2000, and quite frankly, in the scheme of legislation, a 2000 Act is not an old act. So we need to look to see what is the mischief surrounding the need to trouble the Bail Act in the first place. And that is the first thing to look to, and whether or not there is a mischief that needs to be addressed at the Bail Act, which, by the way, has been tested in our court as to its constitutionality without the provision of pre-charge bail. So the existing provisions under the Bail Act have gone through judicial test as to its constitutionality and provides for the considerations that a court will take into account in coming to a decision to grant bail. So that's the first thing. Next thing is, we would like to say that there is a misconception in the public space, and I will say it is an unfortunate one, that the courts are granting bail, and these are my words, willy-nilly, particularly in the area of murder. Any attorney at law that has practiced at the criminal bar knows that there's a high threshold when it comes down to murder in getting a judge to grant bail. As you will see, we make reference to the fact that roughly 80% of persons who are before the court for murder are either not admitted to bail or cannot fulfill the bail provisions. So overwhelmingly, those persons, and I'm dealing here just now with murder, most persons who face a murder charge do not get bail. And that remains the situation now. That is to say, they've not been able to satisfy a judge as to the different considerations that are to be applied as to whether they should be allowed to go out into the public. We must have regard to the fundamental rights and freedoms as set out in 13 to 26, I believe, chapter 3 of the Constitution. And we must be mindful of the fact of, and I'm going to say it this way, I cannot think of a more serious constitutional right than the right to liberty. Maybe the other one is the right to life. All right? Let us put that on the table. Right to life, right to liberty. So fundamental is the right to liberty that when you look at, and I believe it is section 14 of the Constitution, sets out the rights and freedoms. Right? And it speaks to the right to liberty. You're talking about an essential human aspect of existence that you must not be locked up. So when you're talking about eroding, circumscribing the right to liberty, you have to act with utmost discretion. Your hand has to be light when it comes to prescribing any kind of provision that is going to be an inroad into the right of liberty. We live in a jurisdiction that has the presumption of innocence. Ancient common law right, yes, our colonial masters gave it to us, but it's a human right across all other systems of justice, whether civil or common laws we have here, which is the right to liberty. So, having said all of that, I want us to look at the section 14, and I'm deviating here from my script a little. We look at...
Just remember, when you deviate, just ensure that the main points are covered.
In the hope of shortening matters. When you look at section 14 of the Constitution, right? Protection of freedom of the person. And you have 1, no person shall be deprived of his liberty except on reasonable grounds. Grounds are laid out. Then it says, so that is one instance. Then 2, no person who is arrested or detained shall have the right. Any person, I beg your pardon, any person who is arrested or detained shall have the right to communicate with his attorneys and so on, soon as reasonably practicable, to be informed in a language he understands of the reasons for his arrest, and C, where he is charged with an offense, to be informed forthwith in a language which he understands of the nature of the charge, and D, to communicate and retain an attorney at law. 3, any person who is arrested or detained shall be entitled to be tried within a reasonable time. and so on. Then you have section 4, which says, any person awaiting trial and retained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. I have read through the Constitution. I do not see any other reference to bail. The only place the Constitution of Jamaica contemplates bail is 14.4. What is bail? Bail necessarily is a restriction on liberty. Why do I say that? Bail presumes that you're going to surrender to custody. Bail is asking you to make provisions to allow you to go out and do your business, which means reporting to the police, giving up your passport, number of other things. The essence of bail is actually, bail is not a freedom from custody. Bail is a restriction of liberty. And the only place you see the Constitution referring to bail is 14.4. What does, so therefore, the idea and the essence of bail being anything other than section 14.4 is a stranger to the Constitution. What does 14.4 say? 14.4 says this: any person awaiting trial, and I pause there for emphasis, any person awaiting trial and detained in custody shall be entitled to bail on reasonable conditions unless sufficient cause is shown for keeping him in custody. Bail, therefore, under the Constitution only contemplates a situation where you're awaiting trial. It therefore means pre-charge bail is not contemplated by the Jamaican Constitution. Unlike England, where they tried pre-charge bail and had to pull it back, where you had parliamentary sovereignty, we, and I will say happily, have a written constitution. We do not have parliamentary sovereignty, we have constitutional sovereignty. And so you'll see at the tail end of my paper, I make references to other Caribbean territories. Mutatis mutandis is the Latin expression I would apply here for all the attorneys in the room and online. Those who are not attorneys, meaning apply where you think appropriate. Not saying that any of those constitutions necessarily are directly on 4 points with ours, but look at them is what I'm asking the committee to do. But the point I'm making is this, and let me just, as we say, cut to the chase. I do not think we can be comfortable in concluding, or this committee can be comfortable in concluding, that the proviso in relation to Chapter 3, reasonably justifiable in a free and democratic society, would apply here. And the reason why I say that is, as I understand it, the bail is to be an ordinary bill and not a special bill seeking constitutional amendment. If my assumption is correct, it may well be that in order for this bill to be constitutional, might well mean an amendment of section 14.4. In other words, you may have to redefine bail. And of course, you know, a constitutional bill will require the usual delay provisions and a 2/3 majority of both houses for it to pass, amongst other things. Okay, having said that, we make a number of observations in relation to a number of the provisions in the bill. The definition of conviction should have a connector at the end of subparagraph B. Right? Is it there? I don't know if that correction has been made. Deciding official, that is to say, the person who decides on this thing called pre-charge bail. This term should expressly exclude the arresting and investigating officers. I don't know if that has been adjusted, or is there a plan to adjust that? And all police officers who have been involved in the investigation. Obviously, we want to guard against bias. In order to remain consistent with 51A2I, deciding officials should be expressly restricted to constables at or above the rank of superintendent. Defendant, it is unreasonable and unfair for a person not charged with a criminal offense to be referred to and treated as a defendant. Because you're not charged, you're not a defendant. And frankly, you go on to make the comment that one of the things that is considered in the granting of bail is the provision of a surety. How do you provide for a surety in a situation where you're not charged? You're not yet in a situation, or may never be in a situation, where you're being brought before the court. What is a surety to do? Secure attendants to come back to the police station? And then now, do we have some sort of provision in place to secure this surety? Providing for bringing back and can't even call him accused or defendant, the citizen to the police station. How does surety provisions work in an instance like this? I believe that if you're going to do this thing, which it is, and I'm saying it constitutionally suspect, it needs to be circumscribed in the way that I've indicated at the beginning of my submissions. While Jambar supported the Parliament's intention to introduce this new concept, it is our position that its wide operation cannot stand up to constitutional scrutiny in a free and democratic society. That is to say, if we even can argue that this is one of those situations where we can get away with the proviso in relation to Chapter 3 provisions. Remember, the nub of my submission is we probably need to amend 14.4. It is without a doubt that this concept impacts upon the constitutional right of citizens, including their right to liberty, privacy, and freedom of movement. We acknowledge that the criminal law on a whole will impact upon those rights. However, in this case, where the impact is unjustifiable in a free and democratic society, the impact is very different and is to the level of an unconstitutional infringement. We take this position because it cannot be that a citizen's right to freedom of movement and their right to liberty are affected on the sole basis that another person has made a report to the police, the veracity of which would still be under investigation in many cases, since there be no criminal charges laid at that time. Pre-charge bail may appear on its face to be a simple matter. However, we urge the committee to bear in mind the following. Many defendants presently incur, and we're not even sure you can use defendants there. Couldn't use it there for pre-charge bail. Many defendants presently incur traveling costs to report to their nearest police station due to distance. And those individuals are mostly of poor socio-economic circumstances. Since there are no restrictions on the reporting condition, a suspect can be required to report daily 7 days per week. And we did a little rough calculation there, $43,200. That a non-defendant, free citizen, might be subject to in a pre-charge bail situation, because we haven't prescribed any limit. Even if the travel expense were $20,000, right? Reporting for approximately half of the week for 6 months. This is an unfair burden, especially if the investigations conclude in the suspect's favor. And even to use the word of suspect there is tenuous. He may not even be a suspect. The expenses incurred by a suspect to comply with the pre-charge bail conditions for 6 months will likely be unrecoverable, which results in unfairness. So, reporting conditions have been known already, and I see member of MP, my namesake across from me in the room, who I know does a lot of criminal work. Yes? Talking, yes. Gentleman with a proper last name. Understands what I'm talking about. During the period of pre-charge bail, based on the present draft of the bill, the suspect's liberty would be at the whim and fancy of a third-party surety, who can revoke his commitment at any time they are displeased with the suspect for personal reasons. And remember, the surety in a regular situation we have here is subject to the court. It's a judge, no longer willy-nilly, because he has to bring the person to court. Is mandated to bring the person to court. But in a pre-charge situation where you don't have court, surety can give it up at any point in time. There are many cases which persons are detained in custody for an inordinate time due to their inability to identify persons financially capable of standing surety. So, I have a feeling that I am close to my 15 minutes. I make reference to some other clauses. I'd like to make a comment here. This act, however it ends up, even if it's a special bill and you are amending the Constitution, even if that were to happen down the road and it's an act of Parliament, habeas corpus is always available. Habeas corpus is a separate provision under the Constitution. Even if you say 4 days, 6 months, what have you, at any time, the Supreme Court has an original jurisdiction apart from the parish court judges. The Supreme Court has an original jurisdiction to deal with habeas corpus. And that is something we need to bear in mind. Why is it that the Supreme Court, never mind what you put into ordinary legislation, has an overriding supervisory jurisdiction, pre or post charge? Why is that? I need for this committee to take that into account, why it is the Supreme Court has that original jurisdiction when they're building in these 4-day provision, 6-month provision, and all of these. You may be acting in futility. That's the point. Putting these provisions in a bail act in these time frames may be self-defeating, given the overriding jurisdiction of the Supreme Court. Section 59B should be removed in its entirety. There's no good reason why a person who has a presumption of innocence in their favor and no pending criminal charges should be required to depend upon a third party to be his surety for his release. Section 512. Oh, by the way, Section 510 should be amended to prevent appeals to a parish court judge against decisions of a fellow parish court judge under Section 52, which is similar to the present exclusion on Section 57 in the bill as drafted. We urge this committee to include a provision that where the deciding official is a justice of the peace or police officer and they have granted pre-charge bail with conditions, they must also give to the suspect a copy of Section 510, which speaks to the suspect's right to appeal their decision, and a copy of the relevant appeal form for the first schedule. Section 512, we feel, seeks to restrict the oversight power of the court beyond reason. Based on how it is presently drafted, the parish court judge can only vary or revoke the bail conditions imposed by a police officer if satisfied that the variation or revocation would not impair the investigation of the offense. Huh? Right, exactly, reversing the burden. This is problematic for the following reasons. Based on how it is drafted, this clause places a discrete burden on the suspect to satisfy the court that he will not impair the police's investigation. It is widely accepted in law that it is difficult and sometimes impossible to prove a negative assertion. The clause has the effect of making the decision of the police with respect to bail almost irreversible, as the judge is precluded from considering all the factors that the police considered in reaching their decision, and thereby restricting the judge to only one factor. Parish court judges are commonly referred to as creatures of statute. Their powers are limited to the specific words in any legislation that impose them. The wording in this section will preclude such a judge from taking into account the injustice that may arise in cases that even this committee cannot now envision. And bear in mind that we have an existing bail act that has withstood constitutional test, bearing in mind the discretions that we all know judges have.
All right, Mr. Williams, you're now 3 minutes over time. I'll give you another 2 to wrap up.
Thank you very much, Madam.
Because we want to pose questions and have some interaction, and we do have a full slate of presenters.
So we welcome the provision. Thank you very much, Madam. So we welcome the provision for the wearing of an electronic tracking device. That is commendable in Section 85C. And we welcome the provision requiring a record to be made on decisions concerning bail. And I would like to make the general and broad point. There's a general and broad point I'd like to make at this point, and I'll just end here. Bail is not a crime-fighting tool. Crime-fighting, there are different tools available to the executive and the police, which must operate against the background of the Constitution. So this committee and Parliament, in approaching the issue of bail, must not in a broad sense approach it like one of those tools you use to fight crime. You must fight crime given the fundamental rights and freedoms that we have for good reason and are just our crime fighting accordingly. May it so please you.
Thank you, Mr. Williams. Let me see if any hand has been raised from our online members. None? All right. Member Chuck?
Your presentation basically is in regards to pre-charge bail primarily. And on page 4 of your written presentation, number 5, you did give an indication that pre-charge bail could be supported in certain limited circumstances. Am I right? I read it.
So,
this guides our position that the introduction of bail conditions before charges are laid, pre-charge bail must be limited to instances where the objective of the pre-charge bail and imposed conditions is to secure a suspect's attendance before the court or to prevent him from committing an offense. I don't know if you could give us some idea of what those situations would be, but let me put a position to you. The vast majority of cases where an accused person is charged and come to court, I can't say I know about recently, but in my time at the bar, most of them were not ready for trial. In other words, in the vast majority of cases, when they come, the police officer, investigating officer, and the prosecution might say the file is still not ready. And we have far too many situations, you will appreciate, especially in the parish courts, where 6 months, a year, the case is still not ready. A good example, is where someone is taken off an airplane. They're found with substance that the people believe might be cocaine or ganja or drugs. And the person is charged, taken to court, given bail in court. I know of a situation recently where 2 ladies were charged with being in possession of a white substance that the police officer believed was cocaine. Employed lawyers and paid a significant sum of money to the lawyers. And on the 3rd or 4th occasion, the investigating officer said the lab, it has turned out not to be drugs. So that those persons have suffered. Now, if pre-charge bail existed, those persons could have been given bail, and to the best of my recollection, the police actually went to their homes and found substance, that they thought was cocaine. And it turned out, at least at the end. Isn't it a situation like this you could contemplate where forensic, ballistic, other, scientific evidence is needed? So you could say to an accused, the evidence need to be tested, but we're putting you on pre-charge bail and make yourself available so that if the substance is positive, then you could be charged. If it is not positive, and can you think of many other situations, looking on the other side, where a person who is suspect, but a case has not yet been made out, evidence is not available, but the police or the allegations is that they may have committed an offense. Isn't that one in which would you support pre-charge bail? Because if you charge the person, immediately, big headlines, so-and-so charge. Apart from that, the person may well have to employ an attorney immediately because they have to go to court, to ask for bail, when if you had pre-charge bail, it may well be granted.
So, Minister, I'm going to be as blunt as I can in my response. All right? The Jamaican Bar Association does not support pre-charge bail. That really is our position. If the committee is so minded to go ahead with pre-charge bail, we're asking that it be restricted in the way we have outlined in our paper. All right? So that answers the first question that you put. The second set of issues that you have raised actually answer the third set of issues which you have raised. No, without pre-charge bail, matters when they go before the court, in other words, person is charged and go before, the system recognizes files being incomplete. And the system currently recognizes ongoing investigations before an actual trial date. That is why you have mention court, and that is why you have criminal case management. So the system already provides for the last scenario that you have outlined. Right now, every day, once you get the bare nub of what you need for the particular charge, put it before the person is charged before the court, it is set for mention. Set for mention on several occasions while the police get the forensic evidence that they need, while they look for the witnesses, while they get the ballistics report, etc., and then you have trial. So the system...
Just a follow-up question.
Yeah.
Is that fair?
It is fairer.
No, 1 second. I mean,
Well, okay.
Long ago in my time at the bar, when I saw a matter, invariably from 1 or 2 little pieces of evidence, I could tell a judge, with due respect, Judge, this case is not going anywhere. So could we start counting the number of times that it will be mentioned before you dismiss it? Okay. Because oftentimes, from when you read it, you know it's not going anywhere. This is like a malicious prosecution. If the person, would your position change? And I'm just contemplating. If the person is told by the officer, you're a suspect because you're found, say, this bag of white powder, or you believe that you are the one who committed the burglary, but we're checking out the fingerprints and what have you. If the person consent, would your position change? So pre-charge bail instead of being charged, because the alternative to pre-charge bail in many cases may well be we charge you, take you to court, you deal with the judge.
Well, you know, Minister, that when you start building a regime calling for the consent of a person in situations like this, you're creating another set of litigation and inquiry as to whether consent was informed, all those sorts of issues. That's another regime you're creating. So would I have a problem in a situation where somebody consents to pre-charge bail? I'm looking at it from a legislative standpoint, which is why we are here, rather than a situation of an individual person as opposed to the policeman. Do we want to legislate to create another regime to deal the issue of consent and pre-charge bail? So you asked an initial question about whether I consider the existing situation fair. Frankly, I do not. I believe that right now, I will say this with all due respect, the system, the system allows for too many mention dates, too many opportunities for the prosecution to get its case right in order to go before for trial. I can give examples. I will recall one particular case, right, that I did in Spanish Town Parish Court. It's a human trafficking case, and it got mentioned for 2 years. I won on a no case submission after the fourth question to the chief prosecutor. After the fourth question, the chief prosecution witness, prosecution throwing the towel. Right? And that is not unusual. When I used to do defense work, I never had to ask for an adjournment. Never. Because the prosecution invariably just wasn't ready. So, the current situation is not completely fair. I believe, quite frankly, sorry to talk in here for myself, maybe we need an amendment to the Criminal Justice Administration Act to build in some provisions to say prosecutions will allow so many adjournments or prosecution allow so much time after which they need to come and show exceptional circumstances why it shouldn't be dismissed for want of prosecution. Maybe that's the way to deal with that rather than a bail bill.
We have other members wanting to ask questions.
I hope that answers you, Minister.
Thank you, Mr. Williams. But just before I take the other members whose hands have been raised, can we agree that a person, Mr. Williams, can be lawfully and constitutionally deprived of his liberty on arrest or detention where that person is reasonably suspected of having committed an offense? Is there any dispute about that principle in law based on what is provided for at Section 14 of the Constitution?
Yes, that's the existing situation. That's
right,
what you're talking about.
So we can agree that it is a correct statement of law that a person can lawfully and constitutionally be deprived of his liberty on arrest or detention where he is reasonably suspected of having committed an offense.
The current law, which is why we have habeas corpus, contemplates an arrest and detention without charge, which is a yes to your question.
So we can agree on that, all right. Can we agree that there are various steps and stages that have to be taken between such arrest or detention, proper arrest and detention on suspicion that the person has committed an offense, before you get to trial within a reasonable time? That there are a number of steps in between. For example, when you arrest and detain someone, you have to move to charge them formally. You have to take them before the court. When you take them before the court, the allegations have to be set out. Bail has to be considered. Legal representation has to be settled. Trial dates have to be fixed. If files are not complete, they have to be complete. There are a number of steps that must be taken between arrest or detention and getting to trial within a reasonable time. And ultimately, to have it tried, the case must be ready on the date is set. If it's a jury trial, for example, jurors must be present. You have a number of steps that have to be taken.
As exists now,
right,
where there is no pre-charge bail.
Right, no. We're talking principle now. I'm not, right. We're
a
talking
number of
principle.
Steps have to be taken
right.
after,
so
obviously.
We can agree that there are various steps and stages that have to be taken between the arrest or detention on suspicion that the person has committed the offense before you get to trial within a reasonable time.
Well, you had within a reasonable time.
Well, that's what the Constitution says, that the person must be tried within a reasonable time. Yes.
Yeah.
Right. But you do not get from that initial stage to that ultimate stage without taking a number of steps in between. So we can agree on that. All right. Can we also agree that the Constitution of Jamaica identifies some rights, and in this case the right to liberty, that can be derogated from because it's not an absolutely guaranteed right? And in respect of other rights, the Constitution provides for a general standard of derogation, and that is that it must be demonstrably justified in a free and democratic society.
Well, the latter formulation applies to all.
Right, that's a general derogation, but the Constitution itself has exceptions to rights guaranteed, as in what is provided for at 14. No person shall be deprived of his liberty except, and it sets out specifically, and also in respect of freedom of movement, where a state of public emergency is declared, the standard of derogation is at a lower level because it's what's reasonably justified.
Well,
but look at the letter of the law. Right. So we can agree in principle. Can we also agree in principle that our court our courts, both at first instance and on appeal, have provided guidance on the kind of analysis that has to be done when you are embarking on a constitutional analysis as to whether it falls within the constitutional remit when you engage rights. And essentially, our courts have adopted the guidance provided by the Oaks, what is called the Oaks test. Mm-hmm. And we have numerous case law which sets out in our jurisdiction the approach to be taken. And if I were to cite one which involves your organization, the JAMBAR, there is a 3-limb test, and it begins with the question as to whether the legislative objective is sufficiently important to justify limiting the fundamental rights. And then secondly, if that answer is in the affirmative, are the measures designed to meet the legislative objective rationally connected to it and are not arbitrary, unfair, or based on unreasonable considerations. And then thirdly, are the matters used to impair the rights or freedom no more than is reasonably necessary to accomplish such objectives. So that we are not looking on constitutional analysis in a vacuum, but that we have clear guidance from our courts on the approach that has to be taken. And it begins to meet that standard of derogation of being demonstrably justified in a free and democratic society in looking at the goal that you're seeking to achieve. Are we on the same page on those matters?
We're on the same page, madam.
We're on the same page on all of these matters. All right. This is a question that I will pose to all presenters. I just want to make sure. Because this is such an interesting exercise, and I think every time we embark on breaking new ground, the concerns about constitutionality, they are proper concerns, and I think the Parliament must pay close attention. But we're not embarking on an exercise in a vacuum. And although we are in a constitutionally, what is the word? Someone has said flux, but I don't think flux is it. But we're in a period where there is alacrity to challenge. But the good thing is that we, at this stage, 10 years, 11 years after the passage of the Charter, that we have guidance from the courts on the approach that must be taken when we're dealing with matters, so that we're not operating from a place where we have no guidance. And it is not enough to speak around the concepts, but if we are alleging unconstitutionality, then we must embark on the analysis that the courts have said in their judgment must be done. We can agree on that, Mr. Williams. All right. On that note, I will Member Williams and then Member Paulwell.
Council Mr. Williams, I sat and I listened to your presentation, quite animated, as always, quite familiar with your spirited representation of clients. No, I just want to go back quickly to the scenario posed by or referred to by Minister Chuck. And I was thinking about that scenario. Now, do you think, and the question is, do you think there is utility or great benefit to be derived from pre-charge bail in those circumstances where, if it is that young lady, or suspect as you would put it, was granted pre-charge bail, then she would have avoided the stigma of a court appearance, in the sense that, and I know you referred to the fact that there are, during court proceedings, there is time allowed for completion of file, time allowed for further investigation, and we know disclosure sometimes, most times is ongoing, and the Crown discloses. But at that stage, wouldn't that person have already been dragged into court? And, of course, we know journalists, are always at court. And of course, that person's name will be dragged as a person being charged. Later on, it turns out that the substance turns out not to be an illegal substance, but she's in court. Wouldn't pre-charge bail in those circumstances, in your opinion, would have assisted her in the sense that she would have avoided that second tier, so to speak?
Let us consider a Jamaican citizen on pre-charge bail. He has to go regularly to a police station in his community. He has to find a surety, I'm talking on your bill, to do something which I'm not even quite clear on, but you have to go out in the community to get somebody to stand surety, and I suppose to ensure your continued reporting to the police station. Everybody in the community is going to know these things. There is a crime that has been committed, and what the community will know is that you are being targeted. You are a suspect. I would think that that person, that Jamaican citizen, who has not yet even had an opportunity to go before the court and start to defend their name, is suffering even more prejudice than the person who is actually charged. Because the person who is actually charged, the public knows there is a process going on that has started that may lead to his innocence being established. But you have this species of defendant, can you call the person defendant, who, according to the community, the police feel says him do it. He's targeted. So the stain is the stain, the public, what's the word? Opprobrium? I forget the name of it. Opprobrium is there in this ephemeral, unclear status of being a suspect but not a defendant.
All right.
Which leaves room for the rumors. So quite frankly, I feel the reverse.
All right, Mr.
I
Williams.
think it's a bad idea
Mr.
if
Williams,
you're talking about...
thank you for your answer. Member Paulwell.
Hi, Madam Chair. I hope you can hear me.
Hearing you loudly and clearly.
Right. Well, the question that I had was before I heard the examination in chief by Mr. Chuck of Mr. Williams, and certainly before your very charming cross-examination of Mr. Williams, which you're one to do with our presenters. And so my question had to do with the statement that he had made earlier about this being an exercise in futility. And I'm wondering, after the cross-examination, if he's still of that view in relation to pre-charge bail.
Before you answer, Mr. Williams, I have a fourth question.
Some more cross-examination?
Not at all, not at all. Remember, this is a very useful exercise.
Of course,
right.
of course,
so,
of course. I'm enjoying.
In this undisputed high crime context that we face in Jamaica, are we agree that the police are challenged in investigating certain offenders for certain offenses, and that time is required to build out a case in a context where witnesses are sometimes reluctant, they are intimidated, and are killed. And the police have intelligence which lead them to reasonably suspect that someone has committed an offense, that the interest of justice must be served in enabling time to build out the case in a Jamaican context where witnesses, sometimes they're part of the criminality, victims may themselves be, but that they're often intimidated, not in all cases, reluctant, even killed, which result in paper trial in some matters. That there is a justice interest to be served in ensuring that the police have time to build out a case without bringing a matter prematurely and then having it stuck in court where it cannot be tried within a reasonable time because the case file is not complete. We're talking in principle now. We're not talking everybody. I'm just saying, is it the same Jamaica that we're in, where the rate of crime far exceeds the current capacity of the police, even with attempts to improve the capacity, just by the stats, which we do not dispute, serious crimes in particular, and that the police are challenged in carrying out investigations, but where they have reason to suspect that someone has committed serious offenses, the interest of justice is served by enabling them time to build out the case, to get to trial within a reasonable time, without having persons locked down in custody unduly.
Madam Chairman, may I just...
We're talking in principle now.
Right. But I would really like not only Mr. Williams to follow it up later on, but other presenters to balance what the chairman has said. The position is you charge a person and we continue where we are now. You take the person to court. Is the burden on that person greater or less than if you say you're reasonably suspected of committing this crime? You can go on pre-charge bail until we think we have a case, which if we charge you, the trial will be within 3 to 6 months. Whereas you charge a person now, and you still don't have all the evidence. You take 6 months to get all the evidence. What I'm really trying to find out is balance the interests of the suspect. I rather the term suspect than defendant, admittedly. Yes, so the suspect is told, you have been alleged to have committed a crime. We have reason to believe you have committed a crime. But we're not charging you as yet. We want to report to the police once per week or until a decision is made. Balance those interests as against charging the person, the burden that person will have to endure in terms of going to court, getting a lawyer, what have you.
I'm going to try and see if I can tie up the three questions, beginning with Member Paulwell and the chairman and minister. I still believe this exercise is one in futility. Reason being...
The exercise of exchanging perspective on matters being legislated on, Mr. Williams?
No. The exercise... Madam Chair.
Clarity, Mr. Williams, clarity and specificity.
I believe it is an exercise in futility to amend the with this new bail bill to replace the existing Bail Act for the purposes outlined. Reason being, I do not feel that the challenge that the police have, and I'm speaking here, and I suppose I'm really speaking as myself and not president of the Jamaican Bar Association, because I didn't consult the council on this one. But hear me out.
Remember, you're here in a representative capacity.
Well, I'm going to say what is on my heart to say. I do not believe that the challenge with the police is time. I do not believe that is what... Thank you. It is not time to build out the case given the current situation, where you can arrest, just as you have said, arrest and detain...
What do you believe it to be? Just in the interest of time, what do you believe it to be?
Resources. There's some other stuff too, but I'm not going to mention in this committee.
So let us say that we agree that there is resource constraint. It does take time to get the resources, doesn't it? So there is no dispute about resource constraint. But if you find yourself in a context where your resource is constrained, you need more, but you still have to act until you get more.
Even with the best of resources,
yes.
I do not believe that the time allowed to the prosecution, which is really what we're talking about, police and the prosecution to build out and prosecute a case is one dealing with time. The Criminal Justice Administration Act does not restrict the time. The only restriction comes in the Constitution, which says you must be tried within a reasonable time. That's a constitutional provision.
All right, Mr.
So what I'm saying is, given what exists now, time, it doesn't appear to me to be the issue.
So you do not agree with the statement that in some cases, in respect of some defendants, not a general statement for all cases and all defendants, that the police, where witnesses are reluctant, they are intimidated, or they have been threatened or even killed, that the police may need time to build out a case.
In those situations, time will not cure it.
No.
If the witnesses don't want to come forward, if you don't have the time, won't help.
All right. So you do not agree with the statement. You do not agree that someone who expresses reluctance to participate or to provide evidence can, with time, be spoken to. You get an understanding of what is a challenge, perhaps if need be. They be put in a victim protection system. You don't agree at all.
I notice you link that to resources.
No, I'm
Witness
asking.
protection.
So I want to address the issue in principle, because I know the conclusion you have drawn and you have clearly stated the position of the bar. But right now, I want to talk in principle. In principle. So it's not a general statement. I'm not saying that for every suspect, because a person who is reasonably suspected of committing an offense is a suspect. So it is not that every suspect is in the same position or that every case presents the same challenge. But since you have indicated your familiarity as counsel who practices at the criminal bar, I mean, you are aware of the high number of cases before the court. You yourself have cited examples of matters lasting too long because they are not ready for trial. And at the end of the day, you'd have succeeded in no case submission because there is no evidence to present. Right. And I believe you've agreed, though you have not said it, that the interest of justice must be served in ensuring that cases are properly investigated with a view to holding perpetrators to account. And for those who are not guilty by virtue of the standards set in law, they ought to be acquitted. And for those who are to be found guilty, they are so found guilty and face the consequences, in principle.
So, in principle...
We're not on different pages.
It appears so.
It appears we are.
You're probably on page 1 and I'm on page 10. I'm saying that, in principle, right, there is no limitation as to time allowable to the police to build out their cases prior to charge, right? And that the existing system
Can you just pause there? Would you say, though, that the interest of justice is served in having matters hang over suspects for a long time without a conclusion being arrived at?
I agree with you.
The interest of justice could not be served in such a situation.
The sword of Damocles must not hang over the head of a suspect.
If we agree that the interest of justice would not be served, then there has to be a proper place for cases to be investigated with a view to trying the suspects, then accused, within a reasonable time. That the interest of society cannot be served by having information, credible information, that someone has committed a serious offense. And you know in criminal law that all of us are victims when offenses are committed. That is why cases are brought in the name of the head of the state,
the point I'm making,
as opposed to a person-to-person on the civil side. So the interest of justice requires that where there is reasonable suspicion that a person has committed a serious offense punishable with imprisonment on conviction, that they are investigated in a timely way with a view to trying them within a reasonable time.
And again I say...
So we are agreed on that?
Well, yes, but again,
Absolutely. All right. So we are agreed on all 4 areas. Thank you, Council. Thank you. All right. We will move to the next presenters. You're free to stay with us if you want. I know it's a familiar place for you. I think Member Jackson, you have your hand up.
Yes, Madam Chair.
Yes.
My intervention is more than a point of order. I really am uncomfortable with how the proceedings are moving forward. The presenters that comes before the committee is being provided an opportunity to provide their thinking and perspective on what is before the House in the bill that is tabled. And I believe they should be given adequate, undisrupted opportunity in a reasonable time, of course, as we have outlined at the beginning, to make their points. It is for us as committee members, having gotten the benefit of those thinking, to consider what is before us. All of us. I sit here and I'm listening to the presentations and the perspectives to get and appreciate those perspectives in considering what is before us. So I will humbly submit that each member to come forward be allowed to put their perspective. Look,
more than 20 minutes?
Madam Chair, with all due respect, this bill has been in the making for over 3 years. And the reason we are told why it was delayed is to make it a better bill. This part of the exercise is to do that too. So if we need to spend some more time, so be it. So that's my submission.
Are you suggesting that the time given to the presenters be enlarged, Member Jackson?
I am simply saying, Madam Chair.
Or the interaction?
No, let me finish, Madam Chair. More latitude must be given to the presenters. We invited them here, not to hustle them through a presentation. They don't have the benefit of deliberating on it as we are, but we want the benefit of their input. And as I said, this bill has been taking over 3 years. So if we have to take a little bit more time, so be it.
Thank you.
That's what happened.
Thank you, Member Jackson. Thank you. All right. Mr. Williams, is there anything else you would like the committee to have the benefit of in light of the concerns raised by Member Jackson?
I'm going to ask Mr. Clark.
Because
my second to...
Yes. There was a point that the bar had considered in relation to Clause 5, subsection 4, in relation to the 6 months. And the concern, and this is one of the reasons why we had a serious concern with pre-charge bail, as it is in this current bill, is that after a person, so you have a pre-charge bail, but you also have the flip side, pre-charge detention. And if someone is refused bail, they can be in custody for 6 months. And after 6 months, they may not be charged and they may be released, quote unquote, unconditionally. The experiences in our country, especially if you look at persons who were detained, for example, under state of emergency, some of them were detained for first a period of 90 days, and then they were rearrested. The lessons that we would learn from our counterparts in Britain who have a similar provision is that pre-charge bail sometimes are misused. And the majority misused. So the majority of persons who were subjected to it, after the period expires, they were not charged. And in fact, if you look at the clause as it is now, one of the problems we had were what are the procedural safeguards to ensure that a citizen who is detained for 6 months, for example, in relation to the murder of XY, is not re-detained after 6 months again in relation to the same murder of XY. And what really does release unconditionally mean? Does it mean that the police have new credible witnesses after a person has detained for pre-charge detention, that the police will not be able to move on that information, that the police can move on it? would the police be entitled to another bout of pre-charge detention, or will they now have to charge the person outright? In our view, Clause 5 does not make that clear enough. That's one. And secondly, in our view, and we hear the example that Minister Chuck had intimated about persons who may be detained and they're just being charged because the police don't have an option but to charge them. That's the only way we can deal with them. And there are persons who have that concern. And in fact, detained us in our deliberation on the bill. But the problem that we found was that, bearing in mind the other problems with our society in relation to how the police currently operate, in relation to persons being detained just to cool them off and not necessarily to really charge them, is the definition of what is reasonable grounds as used in Clause 5, subsection 1. Can an officer just detain a person, not for any real intention behind pre-charge, behind that provision, but just to cool them off? And in light of the concerns that we have with policing and with how long matters take to be investigated and files to be prepared, we were concerned that with all of Parliament's good intention, without fixing the problems that currently exist, that this provision, which can be a good provision in light of our current problems, which are not being fixed, or not being fixed fast enough, can be used in ways that Parliament and the good minister would never have intended. And that's our concern.
I think that any power given can be well used or misused. And any misuse of power is unfortunate. When laws are passed, they have to be implemented and enforced. And they are not implemented and enforced by the Parliament, meaning parliamentarians. And where experience shows the likelihood of misuse, then I think good legislators would see how do you minimize, if not prevent, scope for misuse.
And if I may,
yes,
England had a similar provision which essentially has been procedurally suspended.
Right.
Now, the lessons that have been learned and the reports written about that misuse, we read those reports.
Yes, as have we.
And we were concerned that the procedural safeguards that should have been implemented from the lessons learned there, that enough of those procedural safeguards were not imported into this.
Can you identify one?
Or, for example, we started at the beginning, the first point we made is in relation to a person who is, one, currently detained on a pre-charge bail or pre-charge detention. Can that person be again detained for a second bout of pre-charge detention?
So let's, you want to? Yes.
And another point as well. The point is when a person is detained for 6 months, they spend 6 months in custody, they've lost 6 months of income, 6 months of opportunity to earn. How will that person be compensated for that 6 months detention?
All right. Member
the person.
Charles?
Oh, good morning, everyone. Thank you so much for your presentation, your submission. Mr. Williams, I wanted to be blunt as well. I'm not in the legal fraternity, but I'm just curious. Are you saying that the pre-charge part of the bill should be removed and that a suspect, when a police finds a suspect, reasonable suspicion, that person should be charged and accused before being able to have access to bail? You should just move from being a suspect and you should be accused. You should be accused. You must be charged. Is that what the blunt end of it is? You should be charged.
I recognize.
Not just suspect and pre-detained. You just want to remove all of that. Is that the position of the Jamaica Bar Association?
No.
Okay.
I recognize, and I've said it before, that there are instances in which the police can detain or arrest without charging, right? And I say that against the background that we have habeas corpus at all times, and that's the existing situation. So we recognize that, but what we're saying is, when you offer bail, you should be charged.
as a person that's not an attorney on the committee, which I think was one of the reasons why I was probably chosen, if a police finds reasonable suspicion and brings someone to the police station, just give me a quick example of where we should go from there.
So here's my view. I personally feel, okay, I'm happy for the question, if the police has somebody and there is reasonable suspicion, well, build out the suspicion. That's the first thing. And sometimes you won't necessarily have to rely on...
Say about...
Build it out. Build from the suspicion that the police officer has by... And evidence need not necessarily be a witness. It can be forensic and it can be circumstantial. So there are other ways in which that a policeman can build out the suspicion. The ideal is you should build out your suspicion to a point where you can formally lay a charge before detaining. But there may be instances in which in building out that suspicion, you can't get to that point. And all right, unfortunately, you are going to arrest and or detain for a short period before charging. Long before you have your suspicion, and part of what should create the suspicion is information that the police officer has received, as well as observation and surveillance. So I'm hoping, getting back to what you say, I am hoping what the police should do by virtue of information received, surveillance, and observation, you're able to, in a short time, build out suspicion to a point where you can formally lay a charge.
So the Bar Association is saying that the police should not act until they have built out before and then arrest that person. That's what you're saying?
Yes. That's really where we should go. They should not...
Because I heard you said no cool-off period. I didn't hear that.
Yeah.
That's the position. Okay, thank you.
Just to say, let me ask you what your understanding of what is provided for at clause 5.6a and b. How does that relate? And just to say, since we have non-lawyers and persons who are listening, that the term reasonable suspicion is, we're not starting from first principle. Our courts have opined on that in myriad cases, and what it means is understood under Jamaican law. So it's not, again, we're not legislating in a vacuum or without guidance from the courts on these matters. But reasonable suspicion is the term that is used in the Constitution. And it has been pronounced on by our courts in numerous cases. So I'm just interested in the perspective because there is no difference. I mean, we have to look at what the law is proposing so that it is not a matter of any offense or just to say, I suspect that this man has done something. The officer who has arrested or detained the person and who is involved in the investigation must show the grounds on which it is alleged that there is reason to believe that the defendant has committed an offense.
Well, we're on the same page, you know.
Right.
But
I'm saying, looking at what is provided for, it would capture the concerns that you have raised.
No, but I was responding to the question.
Oh, you do not agree that what is provided for here, for the officer to demonstrate the grounds on which it is alleged that the person is believed to have committed the offense, is an important step in ensuring in guarding against abuse, because this is not the officer who is going to be considering the question of bail for the suspect.
All right, I might not be following you, Madam Chairman, closely, but I'm going to ask Mr. Clark to respond. He seems to be following you closely.
No.
Clark is with the Jambar?
Yes.
I see.
All right. The difficulty is, if you look at clause 5.6, as I mentioned, it follows clause 5b, clause 5.5. So clause 5.5 speaks about the inter-party application, and clause 5.6 speaks about what the judge would consider at that stage. But in any event, so you're correct, Minister, or Chair, in relation to the fact that the judge would consider these things. But as it's clear, judicial opinions sometimes differ. And what one judge may consider to be...
Legislate against that.
No, I'm not saying we're to legislate against it. But ultimately, what is really being done by the pre-charge provisions is that currently under our Constitution, we have 24 hours within which a police officer can detain you and must charge you. We're extending that period from 24 months to 6 months in one
not
instance.
24
hours first. So currently, we have 24 hours within which a police officer can detain you and make a decision to charge or not. And if he hasn't charged you within 24 hours, he must be released. Now with this new revolutionary clause, we're seeing that 24 hours changes to 6 months in a first instance, possibly. And after 6 months, it may change again to another 6 months, which can, if one looks at clause 5, subsection 5, be extended by periods of up to 6 months, 6 months, 6 months, without any clear clause.
No, not 6 months, 6 months, 6 months. Not correct.
All right, so which clause
right.
specifically say that?
It's an initial period and a subsequent period.
And a further period.
Right, no, one subsequent period. Just look on what is actually provided for, because I hear the point raised previously by other presenters, but just look on what is provided for.
And as your experience as a former judge will indicate to you that, yes, if one looks at that clause, and that's clause 5, subsection 5, it does speak to a further 6 months. But is there a
and what
specific
happens,
clause?
Hold on, what happens after that? Look what the law provides for.
And after, I do not see, and I would love for Madam Chair to point me to a provision which says that after consideration of clause 5, subsection 5, that the judge is precluded or the state is precluded from making any further application for another further period of 6 months. And yes, other presenters have made the same point.
Look at 7. And in particular, 7B. And tell me what is provided for.
I've seen it, but if you read clause 5...
No, I'm just saying, though.
May deny the application.
Right.
And but if the judge grants the application,
right.
That's one application. Yes. Who is to say another application? What clause specifically say no further application can be made after an application was made under clause 5, subsection 5?
Look at the clause which speaks to the time frame. Let me just pull it up from the clause by clause.
That's clause 5,
subsection 4. But I think
4,
we are
conflating
a number of issues.
No,
5.4.
5.4. 5.4 speaks to 6 months.
Yes.
But yes. I'm saying that there's no other clause that say that's initial period.
No, but if the application is denied, it tells you what follows after that.
That's clear, but if it's granted, that means you're detained for a further period of 6 months. After you're detained for 12 months now, who is to say at the end of the 12 months?
No, read 4 again. If there needs to be some clarity, but read 4 again and see what you understand it to mean. But while you are reading it, let me just say that I hear the concerns raised, and it seems to me that there are a number of things that are being conflated. So one of the concerns, which is where you began, Mr. Clark, is the possibility of abuse. And you're saying that the law does not specify that a person who was detained, put on bail, or remanded, pre-charged, should not be charged again after the period has elapsed.
I'm saying after a person has been released unconditionally, as the language used in clause 4 states.
So even more narrowly put.
Yes.
So let me just make sure I'm getting the concern raised. You're saying that the law does not specify what should happen to a defendant, and the term is used non-prejudicially. It's someone who has to answer to something, because just the CPC will respond, but since it has been raised, I'll just tell you that there was a lot of debate as to what term should we use. Should we use suspect, accused, and convict? And then one set of research showed that use of the word defendant may be less prejudicial because it's merely speaking to someone having to answer. But we will get to that because it's one of the points raised. But so you're saying that the law you're concerned that the bill does not specify that a person who has been released because no charge was preferred within the time allowed for the case to be built out should not be charged again.
No, we're not, just to be clear, we're not advocating that that person who has been released pursuant to what is Clause 5, subsection 4, should not be charged, especially if the police now has a witness.
All right. So let me
that would not be in the interest of justice.
Right.
But what we're saying is that there's nothing that precludes that person from again being subjected to pre-charge detention.
Right. Right. So, and I think it's a legitimate concern. Thankfully, it is a matter that was contemplated in the policy development. And I can tell you why it has not so specified. I think any concern about abuse in the exercise of power is a real one. We have too many examples in the jurisdiction of cases successfully presented to the court. But remember now that we have the principle of autrefois acquis and autrefois convict.
Which wouldn't apply.
Right. So that the question is, and as a general rule, time does not run against the crown in preferring a charge and investigating a matter. The only time it runs is where a statute creating the offense so specifies, as a general rule in criminal law. So the real question is, what is the detriment to an accused person, and wherein lies the interest of justice? So that, hold on, if it is that the law, as we understand it now, does not preclude a person who has not been acquitted or convicted to be brought back before the court to answer charges, should we then limit it under these circumstances? That really is one of the questions. Because remember now that even where someone was tried, even where a plea has been entered, the director can enter nolle prosequi and bring back the person, and it is constitutionally permissible in our jurisdiction, notwithstanding any concern that has been raised. And I think Monica Stewart is the locus classicus on that matter, where the nolle prosequi can be entered at any time before sentence is handed down and the court becoming functus. So I'm just saying this to say, without getting into granular detail and complex legal issues, because I know non-lawyers are listening on, there are complex legal issues that have to be taken into account in the criminal law, because we are not legislating in isolation of settled principles of law. But any concern of abuse is always a genuine concern.
Can I assist the non-lawyers? Very quickly.
Yes.
So what we're talking
I've heeded Member Jackson's admonition.
Right.
That's so interesting is the subject matter that we should allow.
If I take a minute, I would have taken too long. But what we're talking about here is bail, pre-charge bail. Ordinary citizens, without being subjected to bail conditions, there is no limitation ordinarily as to when they can be charged for a crime. But it is in a situation where you're not subjected to bail conditions, right? So it's not that, so the sword of Damocles, in a sense, is hanging over the ordinary citizen anyhow, because most crimes almost all crimes do not have a limitation period. So what we're talking about here is what this bill is, it can potentially do with that 6-month provision if there's a continuous re-granting, right? Is that you would be subject to these bail conditions indefinitely without you ever being charged. That is the basic point.
I don't know.
It is possible because if you read this thing, the only time it stops when they deny it.
No, remember the
Suppose
provision.
the judge keeps granting.
The provision kicks in, you know. The provision kicks in where the person has been arrested or detained. And it's not for any offense. The offenses are specified. So we're not talking about an at-large situation. And that's why I've been at pain to say, read fully and carefully. Because it is a common practice in this jurisdiction where people are arrested and detained. Now, in Jamaican law, an arrest or detention on reasonable suspicion that the person has committed an offense is not an arbitrary arrest or detention in law. It is not in the Jamaican jurisdiction or in any jurisdiction. It is not. That's what our courts have pronounced on in myriad cases. So the arguments are quite, you see, when we come to, that's why I'm so interested in the arguments being presented, because we're all in a learning context. But I would be less than candid if I didn't say that I'm very concerned that the nuance analysis that is required with the guidance that the courts have provided when we allege unconstitutionality is kind of missing so far. And we're speaking generally because there is so much grievance in the society. So I understand the concerns, you know. There's a lot of grievance in the society and in particular in the justice system. But a society is one that unfortunately is one where the high level of crime and violent crimes in particular makes it difficult for all of us. Member Rodriguez Campbell.
Thank you, Madam Chair. I have two questions for Mr. Williams, but Madam Chair, can I ask also that the pronunciation by the courts on the issue of reasonable suspicion, for those of us non-lawyers like myself, is it possible for some of those pronunciations to be shared with the committee members?
I wonder if Jambar President, Mr. Williams, could, certainly, I mean, between the chambers and the LRD, we can provide. But I'm sure the Jambar representatives, as good practitioners, could also assist. For those of us who practice criminal law.
Once we see a draft, we will happily.
Once you see it? No, they're asking about just the case law, which has given guidance on what amount to reasonable suspicion. So we have a lot of it in cases of assault and battery in particular, both on the criminal side and on the civil side.
So will the committee...
So I really appreciate some of that from LRD.
No, but here's the problem. The problem isn't with the terminal. The problem is not only with the terminal. The problem is that it is police officers sometimes who will be deciding what is reasonable grounds.
Right, I understand where you're coming from, but I just ask us
Yes, Member Rodriguez. The short answer is yes. We can provide it to assist the non-lawyers. But remember, for every power that is granted, someone has to exercise it. For every discretion that is given, someone has to exercise it. And the question is not whether I agree with how you have exercised it, but whether it has been properly exercised, even if we come to different conclusions. And that is why in law, where judicial discretion is in question, an appeal court, so says the case law, even if it would have come to a different conclusion, it does not interfere with it if it is properly and judiciously exercised. And that's what the case law says.
All right. And then for Mr. Williams, when you were originally closing your statements, you said that the matter of bail is not a crime-fighting tool. Did I hear that correctly?
Yes.
Why would you make that statement? What's the idea behind it?
The idea
That's my first question.
Right. I suspect, pardon using that word, that the mischief that is being addressed by this bill is to assist the police in detecting, investigating, and preparing cases for court. I suspect that is the reason behind the amendments to the bail bill.
So,
and yeah, so what I'm saying is those issues would not be addressed by tinkering with bail provisions, especially since the existing Bail Act has passed.
Sorry, just to cut you there, would or should? Would not or should not?
Well, would not. Even if
but it's not that you're saying it should not.
No. Let me say this. Even if we're to pass this bail bill as is currently before us, you will still have the problems with the police detecting, investigating, putting cases in a proper order for it to come before the courts.
Mr. Williams.
That is my general position. So that I'm saying bail, the provision of bail, like other constitutional rights, exist, and crime fighting, whatever tools are used for crime fighting, must exist and operate against that background.
And then a follow-up question for you, Mr. Williams. We have seen a suite of legislation being put forward. The Firearms Act, we have seen this now, the Bail Act, etc. We have also seen where the police is being retooled, retrained to meet some of those needs that you're talking about. Now, all of these things take time, and we have to trust the process. I noticed that the Bar Association, along with other entities, tend to disagree with some of these legislation. And I understand where you're coming from, but I ask the question, because I think it begs to be asked, what, if any, extraordinary measure would you suggest or support to help with the extraordinary crime levels in Jamaica? Because it cannot be business as usual. What would you suggest?
The measures, let me answer that question this way. The measures that I would respectfully suggest are the measures that already exist in ordinary legislation.
In other words, keep the status quo.
So, Mr. Williams, they have not been working, and we are in an extraordinary situation.
Hold on, ma'am. I was interrupted. I wasn't finished.
Okay.
Which include cordon and search, surveillance, yes, arrest without detention in certain circumstances subject to habeas corpus, and all of those exist in ordinary provisions of the law. So I'm saying we can look to those, right? In addition to properly outfitting the police. I heard the commissioner, I'm going to say it, I heard the commissioner of the police say at one point in time, I think he said that there are 150 or 200 points of entry into Jamaica that are not monitored by the police. That is to say, points where guns and drugs can come into the country that are not monitored. All right, I thought I heard him say that. You can correct me if I have the figures right. So we'll monitor them. Do we have radar covering the entire perimeter of the island? How many, so we call it now, do you think you search at the ports? What do you call it? The
scanners.
The
scanners?
The word slips me now. What you use to search containers, the device that you use to search containers at the ports? Forget what it is now. Scanning machines, yes. How many scanning machines do we have? Sufficient scanning machines? Listen, let us look at the police vehicle on the road now. Just look at an ordinary police vehicle. A typical police vehicle is a second-hand Corolla, which does not have onboard information to quickly pick up the information that they need to pick up. Let us start there. Some police stations don't even have telephone.
So, Mr. Williams, I hear you.
answering a
And
question.
in large part, I agree with you that resources are not fully there. But we also have to take into consideration, Mr. Williams, that things take time. This is the first time that we have seen such a large expenditure for the security forces. First ever. If you look back at it, Mr. Williams, you talked about manning, the Coast Guards manning our ports of entry into the country. Before, I think it was a few years ago, there were no Coast Guard ships to do that duty. I think we now have 3, and I stand to be corrected if I have my numbers wrong. So the resources are being put in place. But if your roof is leaking, Mr. Williams, at your house, until the rain finish falling and you can get that roof fixed, or you have the money to fix the roof properly, you are going to put some pots, some pans, and some basins to catch the water. You will not allow your house to be flooded. So I'm saying to you, all of the things that you have mentioned, I can say without a shadow of the doubt, it's in the plans, and the government, you cannot say they're just planning it. You can see the resources being put in. But security is not our only issue. So I'm saying to you again, right now, it is going to take us some time to get everything done. What, if any, extraordinary measure would you support to just hold the fort until the long-term measures can all be in place? If it is that you would support none, I would appreciate you saying you
As I've said before, and I will repeat it again, the extraordinary measures that we would recommend are the measures that now exist in law. Cordon and search, curfews, yes, and I might add all those measures that are deployed in a state of emergency.
All right, what an interesting conversation. Just to say, Mr. Williams, that you made a statement that bail is not to be used to fight crime. Quite a headline statement. But I just want to share a view, just want to share something with you and invite a reading of the case of Hurnam, H-U-R-N-A-M, against the state. It is reported at 2005 UK Privy Council 49, in which the Privy Council noted 5 grounds recognized for refusing bail and using bail. And that pronouncement of the Privy Council is certainly not consistent with your statement, because the Privy Council indicated the risk of the that bail may be used to achieve certain goals. The risk of the defendant absconding, the risk of the defendant interfering with the course of justice, preventing crime, preserving public order, and the necessity of detention to protect the defendant. So not my words, but what our highest court has pronounced on. And the prevention of crime actually exists in the jurisdiction where it is part of our law that where there is grounds to believe that a defendant, if released on bail, would commit an offense, then that person can properly be remanded in custody. And it is sufficient cause in the Jamaican jurisdiction to keep someone in custody. So just to say that as populist as that statement is, it is not accurate in law, in the Jamaican jurisprudence, though I understand your concern, because our highest court has pronounced on the issue, and currently it is a part of our law. Just to say, what an interesting discussion. Member Jackson, thank you so much for the admonition that you made earlier to enable time. It looks like we could be here for the whole day, but very important. I mean, I know the concerns are real, but we have to take great care in ensuring that our statements are correct in law. Right. So just to say that Hurnam and the state, the pronouncement of the Privy Council would say that that statement by you is not correct in law.
Mauritius has their constitution and we have ours.
But it is in our case law. It is in our current law where bail may be denied in circumstances where there is reason to believe that the person, if released on bail, would commit an offense. So you keep them in.
I'm sure the committee does not want us to debate.
No, but remember,
here.
That's why I say
Mr. Clark would love for us to do it.
That's why I say, you know, persons are listening
we have
on.
other persons to present.
So let me tell you how it is important. Because when members of the public listening on, they're going to say, boys, big lawyer, come and make the presentation, you know, lawyer to lawyer, it's serious matter. And if they say something and something not said back, then chances are they're going to go away believing that it is so. And that's why this avenue of the Joint Select Committee to express perspective is so good, but not correct in law, either in Jamaican law or the law that we apply through case law, the unwritten constitution. You know, that's what they say. There is a written constitution, which comprises what is contained in the document, and the unwritten constitution, which is supplemented by the pronouncements on the constitution through the courts. All right, one last thing, because we have the other presenters, and I suspect that we're in for an exciting time.
You know, Madam Chair, while I hold no brief for counsel, Mr. Williams, you know, I think the fear that has driven that statement, maybe the fact that what we're trying to establish and achieve in this society is a professional, well-equipped, resourced police force that does proper investigation, that does, you know, utilize the resources available, the technology to do intelligence gathering, proper crime fighting, and not an over-reliance on a piece of legislation, and see where it's going. But the fact is that we have to do things simultaneously. We have to be incorporating using legislation to back the effort of the police. So there has to be a kind of working together between the executive, you know, the police, the executive, the courts. So it's an entire package. So, you know, I say that to say that in this crime fighting effort, we all have to use whatever is available to us. Legislation, effective police force, professional police force, using its tool and not being lazy and not using legislation to fall into a state of investigative idleness or indolence. So for example, looking at this legislation, Madam Chair, if we were to pass this legislation, and I believe that this legislation could, you know, pass the constitutionality test. That's my opinion. We can discuss that further. But the legislation should not be used as a means of police saying, oh, I have 6 months, so I can sit and be idle. And I know, yes, abuse, the potential for abuse.
Just to say, Mr. Williams, look at clause 5, 6B, B and C, safeguard. No, those are also used when bail is being considered for the first time. The stage at which the investigation, the stage of the investigation so far, and the manner in which it has been conducted, and whether further time would enable a charge to be preferred. There's a reason why those matters are put the way they are put, precisely because of the concerns raised by Mr. Clark, Messrs. Clark and Williams, and what the experience and the peculiarities in the jurisdiction threw up. Right? Man and man believe that you can just pull off a man aside and say, you know what, I have an issue with you. So hold a little time in the lockup there and cool off until. That is why part of the safeguard is that you have to demonstrate to somebody else.
Very well.
Right? And one of the questions raised out of the SOE consistently is, what has happened to the investigation? We haven't seen it come up. So you know what? Again, having regard to those peculiarities in the Jamaican context, you must demonstrate where you are. You must show the manner in which you are conducting the investigation, because there is a standard to be met in the process. Unless you have any other comment.
Well, you know, it's just that I wanted to highlight that, you know, that aspect where Jambar is coming from. You know, there is a kind of distrust of our police,
yes,
you know, and can we trust them with a sensitive piece of legislation? You know, abuse will always be there.
No, member Williams, station bail is granted as a matter of course, with duty counsel present to honor the provision in the Constitution of ensuring that there is availability to counsel. But two other things I want to say, that while the concern is shared about the improvement in investigative capacity that is required, the truth is that we're not where we were last year or the year before in investigative capacity and the resourcing of the police. We are not at all. And in fact, there are many cases where the public, members of the public have expressed shock, but joyful shock, that the police could have successfully completed an investigation. That quintuple murder that happened in Clarendon, horrible case of capital murder. I mean, the convict did not meet the death penalty in the end, but a good demonstration of the improvements in the force in dealing with complex investigation, to the point where, when the evidence to be presented before the court was disclosed, a plea was taken. To the point where, strategically, a plea was entered on the first occasion to mitigate against the sentence of death, notice of which the DPP had given could be not applied. Not that it couldn't be, but that the better view is that in all of the circumstances. So I think all of us who operate specifically in the criminal justice system share the concerns. And you can take comfort in the fact that coming to this piece of law, we have looked very closely and deeply beneath the surface. So when we speak about peculiarities in the Jamaican context, those are the peculiarities, because the work is informed by real data and real evidence in the field. The last thing I want to say, just to correct Mr. Clark, who spoke to a 6 months of detention, that's really not what the law says, the clause says. And again, accuracy matters, accuracy matters. So the talk of 6 month detention, the 6 months relates to release on bail. And the truth is that there is a flip side of the detention, but this provision is balancing two goals: ensuring that where lawfully and constitutionally someone has been deprived of their liberty on suspicion that they have committed an offense, and having regard to the fact that there are various steps and stages that are involved between that arrest and detention and trial within a reasonable time, the interest of justice is well served by enabling the police time to build out their case and not having certain defendants languish in custody where they pose no threat as set out in the law, because the goals to be achieved are also set out. The conditions are not being imposed at large. They are being imposed for specific purpose of ensuring that there is surrender to custody, there isn't interference with the witnesses or with the course of justice. And that is set out in the law. Also, the conditions to be imposed out of court are finite. And I remember when we were discussing whether to include any other condition deemed appropriate for the police, we concluded that the better approach would be not to invite abuse by giving the power and reserving that to the court. The judge is better placed to do the assessment, balancing both sides, not interested in just the prosecution or the defense. And that was part of the careful design which our law says that we must embark on in looking at the relationship, the rational connection between the goal that we're seeking to achieve and how we go about it. So I just say that to say that it's so important, because we're on a learning curve, particularly for counsel at the bar, when you come to make the allegation of unconstitutionality, that the presentations be informed by the guidance that our courts say that we must, the approach that we must take. All right, on that note, let me move to the next presenter. You're welcome to stay on, Messrs. Williams and Clark.
I need to earn some money, Madam Chairman, so thank you very much for having us. And to the members.
Always a pleasure to have you. Next time, please take a read of Hernam. Take a read of it. All right? It may cause you to...
I don't want to stretch out this conversation I have, and I think I'm properly informed. May it so please you,
Right.
Madam Chair.
Thank you, Mr. Williams. Member Jackson, have I missed your hand?
Yes, you did. I wanted to
Oh,
make
Member Jackson.
The
Sorry.
station just now. My understanding of the point made by Mr. Clark regarding the 6 months is that where in section 5.4 it speaks about the extension for the 6 months, and you are directed into section 7b. I know that at section 7 it says the judge may, which would suggest that the 6 months can go even after the second one. And I think that's the point Mr. Clark was making, but I don't think in saying or suggesting that there's a limit as to the 6 months provision is not so by virtue of what is not there. And I recall him clearly asking, direct him to the section of the bill that puts a limit on the 6 months extension that a judge can apply. And that what I'm picking up the concern is that it can make for an indefinite detention.
So the provisions have to be read together. What is the policy behind the law is a maximum time for a person to be placed on pre-charge bail to enable the police to build out the case to prefer the charge. So 5.4 says where a defendant who is arrested or detained but has not yet been charged is released on bail, if a period of 6 months or such further period as is extended under subsection 5 has elapsed without a charge being preferred against the defendant shall be released unconditionally. So this take into account an application that would be made by the court and the powers of the court at 7. We can haggle when we determine as to whether it is provided for us clearly, but I'm telling you that is what is intended, that you are given an initial period, and the period was determined based on the real data that came up from the field about the type of offense. Remember now, it's not every offense that someone is going to be put on pre-charge bail. They are specified. They are the serious offenses specified in the schedule, and these are offenses that are punishable with imprisonment. In fact, just to say that at the development stage, the question, we went through different iteration, and as part of the safeguard, it was only offenses punishable with imprisonment, even though there are serious offenses that work in conjunction with other offenses to facilitate the kind of sophistry in the criminality that we're seeing in the jurisdiction. But again, as part of the safeguard, we have narrowed it. So bear in mind that it's not any and every defendant. It's not any and every offense. And 4 has to be read in conjunction with 5, and 5 has to be looked at in conjunction with 7.
Madam Chair, I hear you.
Yes.
I hear you made it clear about what the policy provisions
right.
are. I recall clearly Mr. Williams from the Bar Association made the point that parish judges are more a creature of what is in the law.
Yes.
The word because of the law. So what is a policy intention in the promulgation? If it is not clearly and explicitly reflected in the law, then you're creating a kind of lacuna in the law itself. And in such situation, you need to stop that gap by making explicit provisions where it is not intended to occur.
So, Member Jackson, just to say that
That's all I want to say.
Yeah.
No, I understand the point. I understand the point. But if you look in the current Bail Act, you will see that judge and court are differently defined. So in this bill, the judge means a judge of the parish court, a judge of the Supreme Court, or a judge of the Court of Appeal. And that takes into account the state who has jurisdiction for it. In respect of the pre-charge bail, we have placed the matter for determination in the parish court, again taking into account that everyone resides in a parish and stays in a parish. So if the person is alleged to have committed the offense in a parish, even if on any of the many technical principles they may be tried in Kingston, indictable offenses, not only where the offense is committed but where you are arrested, we are still placing it as proximate to you as possible to minimize the disruptions. But everything has consequence, you know. Everything has consequence. So that point about the clarity required to our mind is provided for in how we define judge. And the provision speaks to a judge. All right? Thank you so much. But when we come to the internal deliberations, we can look more at it. Because I think in spite of the views that we may have, I believe that I should like to think that we share a common goal of wanting to address the real problems. I mean, I have to say that I'm a little concerned that Mr. Williams' position is that we keep the status quo. Next presenter. Just before you come on, Mrs. Harrison Henry, we're now at 11:23. 12:23. We have the whole day, but I think members and persons in attendance may need a little lunch time and a little break for refreshing. So at some point we will have to take a break. But let me move to the presentation from...
Thank you, Chair.
Madam Chairman, before we continue, sorry to interrupt, I don't think it's likely we are going to get through all these presentations. So I think we, apart from Mrs. Henry Harrison and maybe one more, the likelihood is that we won't be able to take the others. So if they can remain, and the truth of the matter is that you don't want to remain, and then at 1 o'clock, which is, I suspect, or soon after, then you're told, we won't be able to take you.
All right. I see from what has been submitted, they are of varying length. I see a hand. Who is that?
Yes, Chair. Andre Shackelford here from the Faculty of Law.
Mr. Shackelford.
Yes, my apologies for coming late. We were actually listed to present before the Jamaica Bar Association. So I just threw that into the mix for how the proceedings go forward today.
Right. You will proceed, as in follow, the independent counsel.
Very well.
Chair, it's been 12:30. I will not be able to stay beyond 1 o'clock. And in light of our sort of scheduling here, wondered whether or not we could be rescheduled, which would facilitate my leaving now and returning. And it appears that the committee has other parties ready to present. I had not anticipated, Madam Chair, that the first presentation would have exceeded the 25 minutes. And we knew that there would have been time for discussion.
You see how you can't win, Mrs. Harrison Henry? I was trying my best to facilitate, and then I was admonished by Member Jackson. But I understood, and I took it in the best light, because we are breaking new ground, and I think, I understand the interest, and Yes.
We're grateful. Madam Chair, I'm thankful for those considerations. Nonetheless, the discussions are so important, and that is why I would prefer to be rescheduled rather than make part of the presentation now. We take a break, we take another part. Remember, the public has to have an opportunity to follow. And there are matters that arose, such as reasonable grounds, that I would like an opportunity to explain what that means, because I think a number of the problems we faced previously related discharges duties with that being at the front of his head.
And thankfully we have the guidance of the court. And just to say that your organization, the Independent Jamaica Council of Human Rights, founded by the legendary Dr. Lloyd Barnett, has played such an important role on the human rights watch landscape in Jamaica. So we certainly are very interested. This ministry has portfolio responsibility for the protection of human rights. We wouldn't want to shortchange the presentation, but just to say, it's still not at large. It still has to be time-bound. So I will up it where necessary from the 20 to 30 minutes, because it does appear that the discussion may be a little more complex and the interaction between us. So yes, guided by my senior member truck, we would accede to your request. The faculty is present, Mr. Shettleford, so we would take the presentation.
Grateful.
And if you want to stay on until your 1 o'clock departure time, you're welcome to do so.
I think I will leave now, Madam Chair.
Very
Thank you
well.
so much.
But thank you so much for coming, Mrs. Harris. And I'm sure you also have interesting perspective, having served us as our public defender, outgoing public defender. So thank you for taking the time. All right, so we probably, if the seats are being vacated here, we'll ask you to just exchange seats and come up. Minister Chok, can you?
Mr. Shackelford, you can proceed.
Certainly. And Shekel. And E.
Huh?
Shekel.
Shackelford.
Shackelford.
Yes.
I know it's a name you're familiar with. Chair, once again, I do repeat my apologies for arriving late. But I do think the presentation of the Faculty of Law does fit within the flow of the presentations that is coming after Jambar. Because I believe the Bar Association's presentation focused on pre-charge detention and also detention before trial, questions of bail arising before trial. And the Faculty of Law's submission focuses on bail pending appeal. Now, before I get into the meat of the faculty's presentation, I would express agreement with a lot of what the Jamaica Bar Association has expressed. And as a backdrop, and this is to the committee as a whole, I don't believe there's any doubt in the minds of lawyers, the public at large, or the various human rights associations that the interest to be served or the policy being pursued is a noble one, and in fact one which is necessary in our society. However, as was highlighted earlier, balance is key. That is, how do we balance the interest of fighting crime and violence with the rights of individuals? And it's often easy to consider questions of rights as esoteric notions not tied to reality, but in fact they very much are, and a large majority of our citizenry can be subjected to, in very real and serious ways, adverse consequences if that balance isn't properly struck. So once again, the focus of the Faculty of Law's presentation is on the question of bail pending appeal. And there's a certain curiosity which is raised by the second schedule of the Act, in particular Part 2, in which certain serious offenses are listed. And the second schedule is headed, offenses for which an application for bail shall not be made after conviction. Now, the first curious element of that is that that heading in the second schedule doesn't have an enabling provision in the actual bill. So there's nothing which says that these listed offenses ought not to attract bail post-conviction. There is something in relation to offenses which are not listed and certain conditions in relation to the grant of bail, but the reverse isn't stated. And that's problematic. And as a starting point, it's useful to highlight that questions of bail are common law rights. And I know that we don't have a committee that's full of lawyers.
Sorry, I missed it. You're saying that the schedule which speaks to, which sets out the offences for which bail shall not be
made after
is not provided for.
No, there's no explicit provision in the bill which represents that notion or represents that idea. Once again, it can arise by implication.
Right. I don't wish to interrupt the presentation, but just look at section clause 13.
Yes, 1A. I know. That's what I referenced.
Okay.
That it arises by implication from clause 13, but something that's important and fundamental ought to be stated explicitly. So, and the idea or notion behind clause 13, as I understand it, is that there are limitations on the grant of bail in relation for convictions, flowing from convictions which are not listed. But once again, the reverse isn't explicitly stated.
So I know the committee's preference is for us to hear out. Because I had stepped out, I'm just trying to clarify so I can understand. You're saying that what is provided for at clause 13 is only implicitly dealing with the
scheduled offenses.
The part 2 of the schedule?
Yes.
Implicitly, not explicitly.
It can arise by implication. I am going to discuss why that's a problem.
I'll wait to hear. I'm just trying to understand. Okay.
Right. So, questions of bail arise through the common law, and it's inherently a common law notion or a common law idea. And as an extreme oversimplification, a certain set of norms developed through the courts over centuries, and that's what we term as the common law. Oftentimes, common law norms are overlaid by statutes, such as statutes which we are discussing now, and everything needs to be underpinned by the Constitution, which is, of course, the supreme law of our land. So, bail is a common law right, and once a statute is removing a common law right, it ought to do so explicitly. So that's a general notion of statutory interpretation. And it may also remove a common law right by necessary implication. However, things go one step further when you're talking about a common law fundamental right. And a common law fundamental right can only be removed by explicit language in the legislation. And in the submission, there are several footnotes to the various authorities which establish these notions and establish these ideas. So I don't believe there can be a question that ideas of the grant of bail, whether pending trial or pending conviction, are questions which engage a common law fundamental right. And as such, if that's to be affected, there needs to be an explicit enabling provision doing so. However, that's not the end of the story. Because even if there is such an explicit enabling provision providing for the idea in part 2 of clause 13, that is that these offenses are not to attract bail after conviction, there's still an underlying constitutional conformity question which arises. Now, to get certain things out of the way, Section 14 of the Charter of Rights treats with bail pending trial. So the explicit constitutional norm deals with bail pending trial, and there's nothing explicitly stated in our Charter of Rights with respect to bail pending charge, which I think we can all agree must be protected, and questions of bail pending appeal.
Is a precursor to trial.
Pardon me?
Charge is a precursor to trial.
Indeed,
right.
But you know how interpretation can play out. And the second thing to note is that the presumption of innocence doesn't apply in relation to bail pending conviction. So for bail pending trial, there's of course the fundamental idea of presumption of innocence. When someone is convicted, that idea goes out the window. However, there's still a right to bail pending appeal as a common law right. And I would suggest that that idea is not one which can be removed by ordinary legislation or even a constitutional amendment. Now, support for that can be found in cases which I'm sure the committee is familiar with. You have Karate and the state from Mauritius, which dealt with the question of a constitutional amendment in Mauritius, removing the right to bail where certain charges are brought against an individual. And that was a constitutional amendment. And the Privy Council struck it down as being unconstitutional because it ran contrary to the idea of Mauritius being a democracy. And the Mauritius Constitution stated that Mauritius is a democracy, as the Jamaica Charter of Rights provides explicitly. So,
curiously, all right, I'll make the comment afterwards. Very interesting presentation.
Okay. Now, ideas of bail pending trial have arisen again recently. I believe you should be familiar with the case of Charles and, I believe it's Charles and the state, no, Charles and the Attorney General of Trinidad and Tobago from Trinidad. And once again, questions there were raised of the removal of any judicial discretion or judicial element in questions of the grant of bail. And once again, those ideas were found to be unconstitutional. But once again, the context for those cases is that you're dealing with bail pending trial. And also an important point to note is that the Trinidad Constitution provides that the Parliament can explicitly pass laws which are contrary to the Constitution if a certain majority is met, so on and so forth. So in both Mauritius and Trinidad and Tobago, you had truly extraordinary pieces of legislation being passed. In Mauritius, an actual constitutional amendment, and in Trinidad and Tobago, a law which was passed with the requisite majority in the House and the Senate, which was explicitly contrary to the Constitution. In both cases, they were deemed to be problematic. Perhaps one other case one can throw into the ring is a decision from Uganda, which is the Foundation for Human Rights Initiatives and the Attorney General, where the question of bail pending appeal was raised. That's at footnote 9, if you're interested in finding the reference. And questions of bail pending appeal were raised in Uganda. And the legislation passed there removed the right to bail where an offense attracted a custodial sentence of 5 years or more. And once again, the Constitutional Court there found that to be unconstitutional. So how does that play out here? How does that relate to the Jamaican context? Jamaica is a democracy, explicitly provided for in the Charter of Rights. And it's being recognized judicially, extrajudicially, academics writing, so on and so forth, that a democracy not only includes the right to choose who governs, it doesn't only include the right to participate and deliberate in important matters of state, but it also includes the rule of law, and it also includes the protection of fundamental rights and freedoms. Once again, Karate is an interesting case because there's an actual amendment to the Constitution which said in cases of murder, in cases of drug trafficking, so on and so forth, no bail is allowed. And in those circumstances, the Privy Council found it to be problematic. I say there's no reason conceptually, textually, why those ideas don't apply to bail pending appeal. And before we get into the sort of academic notions surrounding bail pending appeal and the human rights ideas, just to turn to one practical example which is pointed out in the submission. We know that a problem in Jamaica is trial delays. We do have issues of people being detained for an extraordinarily long period of time before trial is heard, and then the trial is heard, and then perhaps a long period between the hearing of that trial and any appeal relevant to that person, whether it's an appeal against conviction, sentence, or both. It is not implausible that someone can spend 15 years behind bars, for example, between the time that person is first detained and when that person's appeal comes up for consideration. I'm not an avid criminal practitioner, so I must just put that out there. So I'm mostly at a commercial litigation bar. But anecdotally, these things are not unfamiliar. And as a matter of fact, judicially, there are cases dealing with delay of trial in Jamaica, more than one case. So it's not implausible that someone can, for example, have a partial defense in his or her favor to murder, is convicted of murder, and that partial defense may have succeeded on appeal, or there's a good chance of it succeeding on appeal. That person wishes to get bail from the Court of Appeal, having served 15 years, and in the ordinary course of things as things are today, that person would usually be granted bail if they have a good chance of succeeding on the partial defense point. But if the policy envisioned by Part 2 of the second schedule to the bill is implemented, that's gone. There's absolutely no judicial discretion on the question of the grant of bail post-conviction in certain circumstances. And that's problematic. And going back to the constitutional question, that's why it's problematic as well. Because the removal of discretion from the court with respect to questions of bail is the primary constitutional infringement which could be found in Karate and could be found in Charles and the state of Trinidad and Tobago.
Is it your submission that this bill has taken away the discretion of the court to grant bail?
That if the policy contemplated by Part 2 of the second schedule is properly implemented, the questions of bail pending appeal with respect to those listed offenses will be gone. There will be no discretion at all.
But wasn't it your initial premise that on conviction there is no longer presumption of innocence because that has been rebutted?
That's not my premise, but
right.
I'm putting that as background.
And
that's relevant.
A person
yes.
who is convicted of an offense punishable with imprisonment would be deprived of his liberty constitutionally.
Yes.
Okay.
Yes, so I'm not disputing any of that.
I see.
But I'm saying that despite all of that, the malady that what's contemplated is the removal of discretion on questions of bail is unconstitutional. Now, it's important to note that at common law right now, if someone seeks bail pending appeal, that person ought to be granted bail only in exceptional circumstances. So it's a fairly high threshold which has to be met by an appellant. And the submission, quite simply, is don't remove that discretion. If you want to tailor what exceptional circumstances are, sure, you can do that. But the removal of discretion on questions concerning bail is how you fall into constitutional problems, essentially. That's the bottom line of the submission. Flowing from that is the question, and just to highlight why it's a constitutional issue, is that we, of course, embrace the concept of separation of powers in our constitutional framework, and questions of sentencing and the grant of bail are inherently judicial functions. And when you remove those inherently judicial elements from the judiciary and put in place firm principles which the court must follow, especially on these types of fundamental questions, you run into problems of constitutional incompatibility. So flowing from that, and of course, there's no clear black and white answer to this, but generally in crafting this bill and in crafting this, which is to become an act in due time, I suppose, it's important that any judicial flexibility which is left, or any judicial discretion which is left on questions in relation to the grant of bail, are not illusory. They're not seeming discretions, but yet the judge dealing with the question of bail is left on an extremely tight rope. Once again, that judge jurisprudence deals with questions of the complete removal of discretion, but I would suggest that it's important not to whittle down the discretion so significantly that there's no
Mr. Shackelford,
flexibility.
You're going over and over the same point, if you don't mind me.
Pardon me?
If you don't mind me interrupting you, because you're going
Sure.
over the same point in terms of if a person is convicted,
Yes.
your position is the discretion of an appeal court judge should not be restricted in terms of granting bail. But
It ought not to be unduly
ought not to
restricted.
be restricted.
unduly restricted.
Right. Well,
because it's restricted at common law right now.
No, but look at Schedule, the restriction are on those offenses in Schedule 2, agree? I mean, murder, where they haven't been convicted, it's life imprisonment, agree? Unless you're sentenced, unless with a time to serve before you're considered for parole. So it's a life sentence. And the other Firearms Act, which was recently passed, there's a minimum mandatory of 15 years. Agree? The point is that these are convictions for which lengthy sentences have been imposed. The question as to whether or not bail should be granted is a matter that can come up on the appeal. In other words, by this I mean the person, okay, can in fact get, if the matter can come to the Court of Appeal quickly, it should just would be dealt with in a reasonable time. So the real challenge I think you have is, why is it an appeal takes so long? For instance, if the appeal can come up within 2 years, I don't think you would have a challenge, would you?
Well, someone is still locked up behind bars, and there may be exceptional circumstances why bail ought to be granted. And I don't think we're on dissimilar pages, because as things are right now, an appeal court ought not to willy-nilly grant bail after a conviction after someone has been convicted. Mm-hmm. The constitutional issue which arises from what's contemplated by Part 2 of the second schedule is completely removing the judicial discretion, and I think that's where you land into difficulties.
Yes, but you will agree that I can't think of many cases in which a person has been convicted for a serious offense in which an appeal court judge even contemplate bail.
Once again, anecdotal from me. But the example I gave about partial sentences, a partial defense being applicable, not being left to the jury in cases where it ought to have been left to the jury, and it seems to be a sufficiently strong case, and that person has been behind bars for the length of the conviction, if the partial defense is applicable, bail has been granted in that circumstances. Anecdotally, I've heard. Once again, it's not my practice area.
And there's no doubt that there are some offenses that application for bail can be made, but not those in the second schedule.
Yes, and I'm saying you're running headlong into a constitutional difficulty.
So it's left to be seen whether, and I mean, these serious offenses in the second schedule, whether it really interferes with the judicial separation of powers.
This is my suggestion.
I know that's your position. But
my suggestion is this, that the Act replicates the idea of exceptional circumstances which already exists at the common law. And if you see policy reasons to tailor that, you tailor it. That you say these are exceptional circumstances or these are not exceptional circumstances, having a look at the data concerning issues of bail pending appeal. But to completely remove the judicial discretion, I think it will be struck down.
Because you see, Mr. Shackelford, the common man is appalled sometimes when a person who is charged with murder or a serious firearm offense is granted bail even before trial. Can you imagine if he's granted bail after conviction? What a common man would say?
It does happen. This is not reported that
But you agree with me? Would you agree with me that, I mean, they're appalled enough because the police, for example, is really upset when a person charged with murder or a serious offense like firearms or rape and so on, that they're even granted bail before trial, okay? But there might be circumstances where they are granted bail. But can you imagine, with all the evidence, and you get a conviction that the person still has a right to bail?
You know, there's this hackneyed phrase that what's in the public interest is not always what's interesting to the public.
But anyway.
The other way around. What the public is interested in is not always in the public interest. But I think it goes both ways.
Right,
yes.
Yes.
That's the extent of the presentation?
The only thing I would add is that it was highlighted by a faculty member that the offenses in Part 2 of the second schedule, once again, I've suggested that you tinker with the policy in any event, but they're very serious offenses. But there are questions as to why certain offenses are listed in Part 1, where bail can be granted. Part 1 is a different framework, a whole different set of norms applied there. But you have, for example, terrorist offenses under Part 1, and they're not under Part 2. Which is supposed to be a sort of more serious category of offenses. And also that there are some serious financial crimes beyond lotto scamming, which perhaps warrant this more heightened attention, which is contemplated by Part 2 of the second schedule. And that's the extent of my presentation.
Thank you, Mr. Shettleford. Did you say you were a lecturer in criminal law and constitutional law?
No, I'm a lecturer at the university, but my main areas are the relationship between law and information, property law, international economic law.
I'm so pleased to see our universities participating and our law school in this exercise. Thank you so much for coming. Are there any hands raised? I do have a few clarifying question and exchange with. So, starting with the view you expressed of what is implicitly provided as opposed to what is explicitly provided at Clause 13. Just for the record, Clause 13 reads that a defendant who A, is convicted of an offense other than an offense listed in Part 2 of the second schedule, B, was out of custody on bail prior to the conviction, and C, appeals against conviction may apply to the judge before whom the defendant was convicted or to a judge of the Court of Appeal for bail pending the determination of the appeal. On an appeal under subsection 1, the judge may grant the application if satisfied that exceptional circumstances so warrant and impose such conditions on the grant of bail as the judge considers appropriate. From where we come from, meaning, through the drafting and the guidance provided, this is an explicit provision. It's not by implication. It's an explicit provision that in limited circumstances, a convict who was on bail prior to conviction and who appeals of the conviction may apply and be granted bail in limited circumstances. And bail should only be granted if exceptional circumstances warrant, and it would be bail on condition. So where we come from, that's not an implicit provision. It's not something you have to imply. It is explicitly provided for.
May I?
Yes.
It's explicit with respect to offenses outside of Part 2 of the second schedule. So that's explicit. I don't disagree with there at all. What then has to be implied is what you do with offenses which are listed in Part 2 of the second schedule.
No, it says for offense right.
Right, so there's no explicit provision for those offenses. The heading to Part 2 says what you should do with them, but there's nothing in the bill.
It stands to reason that if you're convicted for those offenses, you're not, bail is not...
So you're making connections to get to that.
No,
so
it says if you're convicted for an offense other than those offenses, it means that those offenses are excluded once you are convicted from them. That's how we interpret it.
Right, but you would agree with me that involves a little jump in your brain.
No, counsel. If you're trained in the law and it says the defendant who is convicted for an offense other than
the offenses listed in Part 1. I mean, our training tells us that it is read a certain way. I can understand a layman having a little difficulty, but we won't argue too much on it. There is another issue that arises, and that is what happens if you're convicted for those. And I say that on a proper reading of the provision, it means that bail is not to be granted. And it is precisely because of the issue you raised that after conviction, the presumption of innocence is displaced. Because the presumption of innocence is not that you may not have committed the offense. It just means that you cannot be found guilty of the offense without going through due process, where either a plea of guilty is entered or a finding of guilt. You know, it's interesting that people misread what the presumption of innocence means.
We're all on the same page.
I know, and that's why I find the exchange, because, and I mean, you know, you're coming out of the Faculty of Law where there is much learning and research. I recall recently in relation to the quintuple murder out in Clarendon, there was much discussion as to whether the accused was entitled to legal representation. And in exchange with some members of the public, and in particular my constituents, I had to clarify for them that the presumption of innocence, firstly, does not mean that you may not have committed the offense. It doesn't mean you're innocent. What it means is that you cannot be found guilty without going through due process. And at the end of the day, a conviction results either by way of a guilty plea or a verdict of guilty after trial. But that even the vilest of criminal is entitled to representation to ensure that proper due process is adhered to. So I say that to say that because we are on the same page, that after a conviction and upon liability to imprisonment, where you're totally deprived of your liberty in those contexts and your freedom of movement, etc., we could have easily said no bail at all, and we would be on sound constitutional ground.
I disagree.
But we already have in the jurisdiction, as part of, and also part of the common law, wherein in certain circumstances, persons are on bail even after conviction. Now, bear in mind, you raised the example of a partial defense to murder. So self-defense is a complete defense, and if made out, no offense is committed. An acquittal would be yielded. And where the defense of self-defense is raised, the evidential burden shifts to the accused who raises it, not the legal burden never shifts. And the accused must present the facts so that the arbiter of facts can conclude applying the law. But I say that to say that even in a case in Jamaica, notwithstanding any, I'm looking for a word, corruption of the sentencing process. The sentence, when I say corruption, meaning the application of a sentence other than what is provided for in law, because for the offense of murder, the penalty is imprisonment, or if capital murder, death. So it's an imprisonment sentence, not a fine, not a probation, etc. When I spoke of corruption, is that we have had cases where unlawfully fines have been imposed. I think one such case we tracked many years ago, many years ago. Believe it or not, I think a plea may have been, a verdict may have been returned on manslaughter. Don't hold me out, I don't wish to be incorrect, but I recall because it generated a lot of discussion at the time. But the point I'm making that even where a partial defense succeeds to a charge of murder, you're still liable to imprisonment because the murder would only be reduced to manslaughter in the normal scheme of things. So that even in such a case, the convict would be liable to imprisonment. So I keep saying to persons who are asking questions that the principles, as you have so brilliantly stated are not being dealt with in isolation. So I see the major concern is about the after conviction, grant of bail after conviction, and how the second schedule operates.
Yes, and so step one is absence of an enabling provision of the idea which seems to be intended by Part 2 of the second schedule, and the second one is the removal of judicial discretion in questions concerning bail for those offences listed in Part 2 of the second schedule.
But if we agree in principle that the question of bail could properly be taken away in those circumstances.
I don't.
No, I said if we agree in principle based on your first statement that the presumption is displaced and after conviction you are properly deprived of your liberty if the sentence is one of imprisonment.
Right, so that's where we have a divergence.
Right, because the law is guarding, among many things, the right to liberty, which is a qualified right, and recognizing the presumption of innocence, that you can't be convicted without due process.
Sure.
Right. And in those circumstances, the presumption would have been rebutted. You would have been convicted because there would be guilt beyond reasonable doubt, whether by way of a plea or a finding. And if a person pleads guilty, the law is that the prosecution is relieved of its responsibility to prove anything, because you'd have admitted it. I mean, the court does have its own role. So on those two premise, your conclusion would be non sequitur.
Well, that's why I feel that I must step in.
Yes.
And I understand that a lot of focus or emphasis is being placed on the explicit provisions as stated in the Charter of Rights. Right to a presumption of innocence, right to a fair hearing, right to bail pending trial. Those are explicit constitutional ideas. One can open up a whole line of debate about implied constitutional rights.
I would agree that at the very least we must start there in looking at what is explicitly provided.
Well, that's why I'm coming to
and you
now.
Also would agree.
Let me just make the point. So one can open up debates about implied constitutional rights and if they should be or they should not be. But what is clear is that on the basis of certain decisions from the Privy Council, there are certain implied constitutional rights. And one of those implied constitutional rights is the right to bail. And you
but
see
it's set out explicitly in our Constitution, a qualified entitlement, a qualified right.
Right.
So we wouldn't even have to go to the limb of implication because of the explicit provision.
I'll tell you why I'm going to that limb, because our explicit right is for bail pending trial. The implied element comes to bail pending appeal. So once again, if we go back to Karate and the state and what took place in Mauritius, the Mauritius Parliament actually passed a law changing the constitution and saying bail ought not to be granted in these circumstances, explicitly altered its Bill of Rights to state this. And the Parliament felt safe. The state of Mauritius felt safe. We have done this through a constitutional enactment, and we have achieved the necessary majority in both houses of Parliament with which to do this. But the Privy Council said, no, Mauritius is a democracy. Democracy has certain ideas. One of these ideas is the right to bail. And because you haven't altered your constitution to say Mauritius is no longer a democracy, you cannot remove the right to bail. So that's where we get down the line of an implied constitutional right. And I'm using that implication to demonstrate that even if you have an explicit or express right to bail, which covers a certain set of circumstances, there's still that implied right to bail which exists. And I would say that exists post-conviction, and depending on how one uses to use interpretive skills and interpretive principles, it would apply to the pre-charge stage if one thinks that Section 14 of the Constitution doesn't apply to that stage.
Why you didn't focus on that?
Well, I mean, I knew that would attract a lot of attention, so we decided to focus on this.
No. I think. So what's interesting is that you have raised the Malaysian jurisdiction,
Mauritius, not Malaysia.
Mauritius, rather, and some interesting cases have come out of it. One that we have been guided by is Madehu, which speaks to the generous and purposive approach to interpretation and not a literalist
for rights provision of the Constitution. But just to say that, which is along the same line, though you have not mentioned it, but it is one of the guidance that we have heeded in looking at interpreting rights provision, so that if you are arrested or detained for an offense, it stands to reason that naturally you would get to trial for that offense. And there are a number of steps in between the lawful arrest or detention until you get to trial within a reasonable time. But the issue you have raised about the Privy Council's pronouncement, you know that the Privy Council has come full circle on matters, and there is a whole lot of research on it. So the question of whether something provided for in a constitution can be held to be unconstitutional was recently adjudicated on, and the Chandler No. 2 decision out of Trinidad and Tobago, I would commend for your reading, because we do have a long line of cases where the Privy Council and the UK House of Lords, now Supreme Court, went into certain territory. Now, I think, based on what has come out of the court, the better view now being taken, including the Privy Council overruling decisions, revisiting them, is that something that is provided for in a constitution cannot be held to be unconstitutional. You may speak of the undesirability of it, but it cannot be held to be unconstitutional. And that is why the decision came out the way it did in Chandler No. 2, 2022 case out of Trinidad and Tobago. And it also cited, for example, Hines against the DPP out of the Jamaican jurisdiction, putting to rest the thorny issue of mandatory minimum sentence, among other things. So right now, what we're seeing is that the Privy Council itself has revisited its own approach as to what is to be held unconstitutional, and has pretty much said it, that if your constitution provides for it and you are a constitutionally supreme jurisdiction, as Jamaica is, then no court, however aggrieved it is and disgruntled, can find it to be unconstitutional. It can make other comments about it.
What I said was particularly interesting about that line is that the Trinidad Court of Appeal in Charles and the state of Trinidad and Tobago made its decision specifically bearing in mind that the decision in Chandler was pending, and it stated a lot about the different approaches and the different arguments. But when it went to the Privy Council still found as it did, as I expressed in relation to bail pending trial. What I'm not sure of, and I'm glad you raised it because I'll check it. I'll check if Charles was decided before or after Chandler. That I'm not sure. Right.
So just to say, very interesting matters. And as you would appreciate as a lecturer, that any allegation of a provision being unconstitutional has to be nuancedly and studiedly analyzed before a conclusion is drawn. And thankfully, we are now at a stage where there is much guidance, in spite of the myriad perspective that exists on the matter. So, major lesson, I think you raised it, that has been learned and must be heeded in the jurisdiction, is that you cannot constitutionally oust the jurisdiction of the court to consider and grant bail. And so, even though, speaking of lessons learned from where we're coming from to where we are now, even though our Constitution at 14.4 provides for a qualified entitlement, we have given it a generous and purposive interpretation because it's a rights provision of the Constitution, and take the better view that requiring an opportunity to be provided for cause to be shown for keeping someone in custody. And that's why, and this is an issue that we had debated behind the scene, could we or should we say that where these circumstances exist, they amount to sufficient cause? And I remember my learned director of law reform sitting behind you after we did the analysis, in our discussion pointed out that if we are to take the purposive approach to the interpretation of the rights provision and not the literalist,
then we have to provide an opportunity for the cause to be shown and a decision taken, because the very arguments presented, the arbiter may say it does not amount, it does or does not meet the threshold. So there are lots of lessons to be learned, but I'm happy that we are on the same page. I think our only departure is that you're reading that 13 is an implicit and not an explicit provision. But I got the finer point. Really what you were saying is that we should say that in these circumstances bail should not be granted, or that we set out what amount to exceptional circumstances. Yes. All right, unless there is there any hand raised? Mr. Williams, Member Williams.
My lady, Madam Chair, you know, you know, it's hard. One can't escape the feel that we're actually.
This is the only presenter that come and say that on their interpretation, the pre-charge bail is constitutional. In other words,
no,
you didn't say that explicitly, but you provide a route through which that conclusion can be drawn.
Right, but the purpose of
I'm not going to put it higher than you have put it. You have provided a route, which is the same route that we are traveling on. All right?
Curati, the Mauritius case, Privy Council Authority. In that authority, the constitutional amendment related also to post-conviction bail, correct?
I believe so.
Okay. In relation to the, no, so it's based on your understanding, curati is still good law?
Yes, because it's been approved in Charles, which was this year, from the Privy Council.
In this year?
Yes.
So, your position then is that following the curati case, that section 13, in relation which stipulates that the offenses in part 2, that there is no consideration for bail. The Court of Appeal is precluded. A court is precluded from considering bail in those circumstances. Your position then is that that violates the separation of powers. Is that what you're saying?
A separation of powers is a part of it. And there's been, of course, discussion from Karate, Mollison, and DPP, the Court of Appeal Trinidad decision in Charles, and a very brief reference to the Privy Council decision in Charles, and also in Chandler number 2. So how
Charles preceded Chandler number 2. Charles was 2020. So
it was still in 2020.
20?
Oh, Charles was 2020.
Charles was 2020 from my quick look. And Chandler is 2022.
I'll take a quick check on that.
Or not.
My impression is that it was this year.
Yeah, I'll just look. I don't know if it's the. Let me look.
Right, what?
Yes. So you're saying.
Oh yes, to answer your question, is it founded on the idea of separation of powers? Not only. Yes. So there's the separation of powers issue about inherently judicial functions, so on and so forth, and how that's been dealt with more recently. And there's also the question arising from Karate about the meaning of a democracy and what flows from that, and the idea of certain common law rights and how we deal with those common law rights, even when there is a statutory or constitutional angle or element to that common law right.
Yes. So your position then, in light of that authority, is that.
Sorry, Member Williams. In Charles, the board struck down a provision of the Trinidad Bail Act that no defendant could be granted bail for murder.
Yes.
Right. So that is not applicable in the Jamaican jurisdiction because that's not what our law is providing for.
Right, but I'm not dealing with the facts of the case. I'm not saying it's on all fours.
The principle,
I knew the
right.
principles. Yeah.
So just to make it clear for those listening, it is not Jamaica's case law that bail cannot be granted for murder. It
or
is
in our
not.
statute or anything
right,
like that.
not in our statute, not in what our case law has thrown up, and it is not being provided for in here. There are certain restrictions, however, which are quite permissible, having regard to the case law.
So it's a different situation.
Yes, I'm the
Right.
same with principles, yes.
It's clear to say we're dealing in this context with post-conviction.
Yes. It's a very,
Post-conviction bail.
I know a very narrow scope, but
Very narrow
important
scope.
nonetheless.
All right.
I think Mr. Foreman has his hand up. Mr. Foreman?
Yes, good afternoon, Chair. Just for a point of information, the Coirati case did involve a situation of preventing the grant of bail pending trial. It was not a case that dealt with the issue of whether the judicial determination to grant bail post-conviction engaged the separation of powers principle. Just for clarification on that.
Thank you.
Right,
Thank you
thanks
for
for
that
that.
important clarification.
But a question I would ask through Madam Chair. Question I would ask. So did the constitutional amendment passed by the Parliament of Mauritius, did that constitutional amendment contemplate post-conviction bail?
Well, Mr. Foreman has helpfully clarified that. And
Oh, you'll clarify that.
no.
Very well,
Yes.
very well. Okay.
And I'm just making it clear, the scope of my submission draws from these various principles, and I'm highlighting that I think there's a very strong possibility that the removal of judicial discretion for conviction, for the questions of the grant of bail post-conviction is unconstitutional. Now, I'm not saying that we have a direct Caribbean case on that. So I just want to make that clear. I'm just saying drawing on the various principles.
But in making
that
it
would seem
clear,
to be
please
the
have
case.
regard to what is provided for in the bill. So
Certainly,
because
certainly.
persons
And just-
listening on may not appreciate the academic approach that you take, which is quite understandable because you start with the general principle, because whatever those general principles are, they have to be applied. First of all, once they're correct statements of the law, or a better view of the law where there are competing perspectives on it, then they would have to be applied to what is before us. So just for clarity for those who are watching and are not lawyers.
Very well. And
Yes.
just to highlight that the one authority which I have provided on the question of post-conviction bail is a Ugandan case that dealt with that issue, which I think is worth having a look at.
If you analyze it further, if the person were not on bail before, chances are they're unlikely to get bail after conviction, being liable to imprisonment unless real exceptional circumstances exist.
Yes, I don't disagree with that at all.
And it is not the general approach, and I say general emphatically, to or the better approach is to leave it to the court as to what would amount to exceptional circumstances on a particular case. And I mean their guidance, and that is why it is provided for the way it is provided for, because it's a better approach.
Well, what's provided for is
just the exceptional circumstances.
What's provided for are offences outside of Part 2 of Schedule 2.
Right.
That's for context.
Right.
Yes.
But that is because of how those offences are treated, and precisely because, as you've rightly said, after conviction there is no presumption of innocence, and you would have forfeited your liberty anyway.
Mm-hmm. So
Right.
I understand,
Yes.
and I think we're
Constitutionally so.
I think we're lockstep
Yes.
until the question of whether the removal of judicial discretion completely is constitutionally compatible. I think that's the only divergence.
Right.
we have.
So there is no outright removal, just to make it clear.
Well, yes. So, but the policy contemplated by Part 2 of Schedule
And
2 is to remove it. So I'm asking you to revisit that policy.
That is what is currently exists in the Bail Act now, Look at it.
Not a complete removal.
Look at it. There are some offences for which bail is not permitted after conviction.
Oh, very well.
Currently in the Bail Act.
Very well. To the extent that's true.
Yes.
To the extent that's correct, I
Right.
would say that
And those matters have been tested in our court.
I would say those are
Yes.
constitutionally problematic.
Just to say. All right? Just look at it. It's so important because I think so much interest has been generated about the topic. And between the first set of presentations and now, the number of questions arise. It has forced me to reassess my own approach.
because accuracy matters. I think there is shared goal, but a lot of inaccurate statements or general statements without regard to what is actually provided for in the bill. But I want to thank you so much for your delightful presentation. Sorry?
I hope you're not ascribing that statement.
Not at all. I think we have closed the gaps. Close the gaps. And, you know, we're all in a learning curve. The good thing is that there is much guidance from the court. And like I say, it's fascinating to see how the Privy Council has placed itself on a different trajectory about its ruling on what is provided for in a constitution. I could point you to a number of articles where the allegation was that some of what found itself in rulings, particularly around the death penalty, represented personal views, and one particular law lord was identified, not in my jurisdiction, but in the same UK jurisdiction, which has, and because of the concerns raised within the legal circle and the academic community, the board has been forced to relook critically, because it certainly is an unsound approach to say that something provided for constitutionally in a constitutionally supreme jurisdiction is unconstitutional. Lots in a mouthful, but a lot of lessons to be learned. Thank you so much, Mr. Shuttlefoot. Thank you so much,
Madam Chairperson.
All right, it's now 1:22, and we must. May I ask whom else we have? I think the JCF is present, and may I? Sorry, Ms. Golding and Mr. Luars. Whom do you represent? Individually, I see. All right. I think we will have to take a break. The intention was to have broken at 1 o'clock, but we're nearing 1:30. Would say a half an hour, 45 minutes break be sufficient to allow persons to refresh themselves. I noted that the majority of our committee members are online, and I think probably can more easily take their break. But for those present here, would that be okay? 30 to 45 minutes, and we try to get back here 2:30, 2:15, by 2:15. All right, so unless there is another view, I would take the break now, and we reconvene at 2:15.
Sounds good, Madam Chair.
DPM? Member Chang,
yes.
Did you?
Chairman, yes, I'm listening to you, Chairman.
Oh, I see. Not that you were expressing a different view in respect of the lunch break.
No, I was supporting your break.
Very well, thank you.
That time.
Thank you.
Good,
yes.
Very well, thank you.
Excuse me, can I? Hello? Oh, hi. Good afternoon, members and the chairwoman, the JCF. We have a constraint, unfortunately.
Committee is adjourned. We will speak during the break.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
Whenever you hear the following tone, the Office of Disaster Preparedness and Emergency Management, ODPEM, will be giving information on an emergency situation affecting the island. Please be on the alert and listen to your radio and television for further information. This was a test of the emergency alert system, brought to you by ODPEM.
Your government is working for you. On the East Coast, there's the Southern Coastal Highway Improvement Project. The highway, which began in January 2017, is now slated to end in March 2025. Another segment under the Southern Coastal Highway Improvement Project is the Maypen to Williams Field, which is approximately 81% complete. Next stop, the Morant Bay Urban Center. Preparation and demolition exercises began in July 2022 at the Goodyear factory in the parish where the center is being constructed. Construction phase has already started. Third stop, over in Portmore. Plans are afoot to make the Sunshine City the 15th parish. With the parish status comes the Portmore Resilience Park, which ground will be broken by year-end 2022. For in the west, we have the Montego Bay Perimeter Road, starting from Ironshore to Bogue, from Montego Bay down to Montpelier. More updates to come as we reignite our nation for greatness.
The proceeding was brought to you by the Office of the Prime Minister.
Just meds it.
Instead of hurting and fighting each other.
Let's help each other.
We don't need to fight.
We're all here to learn.
Your classmate could be a future lawyer or minister.
Do you know that your classmate or your schoolmate could be a future prime minister?
So here what? Just make daddy proud. Don't have me a worry.
Don't fight or lash out. Violence is never the answer.
Before you pick up a stone,
why not pick up your book?
And just meds it.
We all have our part to play.
Let's end violence.
Let's end violence. Let's end violence.
Let's end violence.
Let's end violence.
Let's end violence.
We must end violence in schools now.
Know your numbers and control the keys to a healthier heart. Know the numbers for your blood pressure, cholesterol level, blood glucose level, and your weight and body mass index. Find out the risks they represent and what you need to do to stay healthy. Talk to your doctor and start making healthy lifestyle choices to prevent a heart attack or stroke.
Remember, gambling is just a game. Choose to gamble responsibly. Set a budget, avoid chasing losses, and stop gambling when you reach your money limits. For gambling help, call RISE 888-991-4146. A message from the Betting, Gaming and Lotteries Commission.
Hey you! Yes you! Let's go on a public sector journey together. Check your rear view and lift the gas. We all rely on public sector workers, from hospitals and care workers to schools, where our children get the education in emergency situations when we're most in need. In turn, public sector workers are paid by us. The current compensation structure in the public sector is complex, inconsistent, and inequitable. That's about to change. Welcome to the new compensation system. The new system is simple and easily understood. It's consistent, enabling equitable application and transparency across the public sector. It will reward high performance and it's sustainable. The government of Jamaica is committed to investing in its people and building a better public sector for
As an inner city youth, I'm a duty to know the laws and my rights. These laws affect all our self-interest and safety.
The law says throwing garbage in public places or on other premises without consent will lead to prosecution. I see it online. I know my laws and my rights. Do you? Know your laws. Know your rights. Respect you.
It's Thursday, December 8th. In the headlines, Prime Minister Andrew Holness on a working visit in Washington. Regionally, Grenada welcomes a Cuban president. And in sports, Windies women lose ODI series to England. This is the news on PBC Jamaica. I'm Simone Absalom Gale. Prime Minister Andrew Holness is in Washington, D.C. for a 5-day visit. He arrived on Tuesday, December 6th. According to the Office of the Prime Minister, Minister Holness will be a special guest for the monthly series Let's Connect with Ambassador Marks today, December 8th. Ambassador Audrey Marks says the upcoming Christmas edition of the forum will give the Prime Minister an opportunity to interact directly with the diaspora and deliver his Christmas message. While in Washington, the Prime Minister will meet with State Department officials to discuss enhanced security cooperation in light of the large number of U.S.-based Jamaican dons who have been influencing the rising crime levels in the island, including murders. The Prime Minister will also address and participate in a Congressional Parliamentary Intelligence Security Forum at the U.S. Senate building, alongside congressional leaders and parliamentarians from around the world. Prime Minister Holness will also have meetings with the Department of Justice, with the Attorney General's office, to discuss the need to intensify action on the prosecution of targeted drug lords and leaders of lottery scams. In further support of his security agenda, the Prime Minister will be joined by the Commissioner of Police, Major General Anthony Anderson, for a working meeting with various security agencies. While addressing a press brief earlier this week, Prime Minister Andrew Holness warned perpetrators of crimes that the government will be relentless in combating their criminal and violent intent. He says the government will continue to build the capacity of the security forces to respond to threats of violence.
And that is all the government is trying to do with the powers afforded to us in the Constitution, to save lives and ensure that people are free from violence. We are entering the Christmas season, and I want all Jamaicans to be able to enjoy the Christmas season, free from the threat of violence. We have some really serious criminal threats facing us, and we have to use all the powers at our disposal.
He says that the tactical effectiveness and efficiency of the police force has improved, and intelligence is being used to nab criminals at the point at which they are planning or committing crimes.
In the interim, we have to ensure that our homicide rate and the level of violence that citizens experience on a daily basis does not get to the point where it threatens the collapse of the state. There are several countries in this region where the level of violence, criminally organized violence by gangs, are threatening the very foundations of the state.
Meanwhile, the Prime Minister says while emergency powers are an important part of any society, the government has no intention of abusing these powers, especially during the period of a state of emergency. He discussed several instances of misinformation, one being the matter of presumed indefinite detention.
The other issue I want to address is the misconception that persons who are detained under the SOE can be detained indefinitely. Nothing could be further from the truth. Under the emergency powers regulations now in place, the Emergency Powers Review Tribunal, chaired by members appointed by the Chief Justice of Jamaica from among persons qualified to be appointed as a judge of the Supreme Court, they must review the cases brought before them in order for any person to be detained for more than 7 days.
The SOEs have been declared in the parishes of St. Anne, Clarendon, St. Catherine, specified areas in Kingston and St. Andrew, St. James, Westmoreland and Hanover. The matter of retroactive payments to public bodies came up for discussion during this week's meeting of the lower house. Opposition spokesperson on finance, Julian Robinson, queried whether all groupings within the public sector that have already signed on to the new wage agreements will receive their retroactive payments in December. Minister of Finance and the Public Service, Dr. Nigel Clark, gave his response.
We are seeking to facilitate members who have already signed with a payment at this time because of the nature of the time that we're in. It is my full intention and my commitment that upon finalization with all of the groups and the new Establishment Act is going to be brought to this House, where the salary of every single position will be detailed and tabled in this House.
He further noted that public bodies have requested and received approval from the ministry to pay an advance to employees.
And this will be public bodies who are not on the consolidated fund and who are not receiving the full amount of back payment, right? Because as you understand, public bodies on the consol fund will be they will be like civil servants in central government receiving back pay from April 1st to December. But those who are not on the consol fund, we have granted them approval to advance amounts up to a maximum of $100,000 to members of their staff in public bodies, pending the finalization of the mapping exercise, at which point the full amount of the back pay would become due.
All registered security firms should start treating their security officers as employees as of April 1 next year. The Jamaica Association for Private Security, JAPS, made the announcement this week. In a statement released on Wednesday morning, JAPS explains that the decision was made at a, quote, high level with meeting of 3 top security personnel in the private security industry, end quote. Noting a Supreme Court ruling which states that security officers are employees, the JAPS says the Private Security Regulation Authority will have to stop giving license to registered firms who don't treat their security officers as employees. In the business report, gas prices are down. We have that plus your usual market updates from Danita Rodney.
Motorists will pay less for gas when they go to the pumps on Thursday, as state-owned oil refinery PetroJam says, down by $4.50. E1087 will sell for $167.16, and E1090 will sell for $171.13 per liter. Continuing with a decrease of $4.50, automotive diesel oil will sell for $212.59, and ultra-low sulfur diesel will sell for $220.51. The price of kerosene, up by 25 cents, will sell for $207.20. In the meantime, propane cooking gas will go down by $1.17 to sell for $58.64, while butane will move down by 50 cents to sell for $66.67 per liter. Remember that retailers will add their own markups to the announced prices. Scotia Group Jamaica has been awarded Bank of the Year 2022 by internationally recognized UK-based banking publication The Banker. The award celebrates increased product innovation, digital transformation, and the widespread recovery from the COVID-19 pandemic, and is contested by the leading financial institutions in the world. The Bank of the Year 2022 award is one of two major banking awards that Scotiabank Jamaica has captured this year, included being recognized as Best Consumer Digital Bank 2022 by another world-renowned publication, Global Finance Magazine. Now for your market updates. In foreign exchange trading for Wednesday, December 7, the US dollar sold for an average of $154.53. The Canadian dollar ended trading at $113.65. The pound sterling traded for $188.27, and the euro sold for an average of $163.07. In JSE trading, the JSE index advanced by 3,125 points. The junior market index advanced by 27 points. The combined market index advanced by 3,166 points. And the All Jamaican Composite Index advanced by 4,446 points. Overall market activity resulted from trading in 106 stocks, of which 47 advanced, 43 declined, and 16 traded firm. Stocks advanced for Access Financial Services Limited, AMG Packaging and Paper Company Limited, and Barita Investments Limited. Stocks declined for 138 Student Living Jamaica Limited, Berger Paints Jamaica Limited, and Cargo Handlers Limited. Trading firm were 138 Student Living Jamaica Limited Variable Preference, Future Energy Source Company Limited Ordinary Shares, and Jamaica Public Service Company 9.5%. The overall volume leaders were Wigton Wind Farm Limited Ordinary Shares with over 8 million units, Trans-Jamaican Highway Limited with over 1 million units, and Unit Medical Disposables and Supplies Limited with over 800,000 units. In regional stocks, on the Trinidad and Tobago Stock Exchange, Plico Investment Fund was the only active security posting over 3,000 shares. On the Barbados Stock Exchange, Insurance Corporation of Barbados Limited was the volume leader with over 40,000 shares. They were followed by Government of Barbados Bond Series B, which traded 11,000 shares. In regional business, the Government of Guyana and the Hess Corporation entered into a historic arrangement that will see Guyana earning $750 million for saving the rainforest through a special carbon credit schemes. Now that Guyana has these certified credits, it can earn millions more. More on that.
Of Guyana, an area equivalent to the size of England, is covered in forests. But that figure isn't just nice to hear. It signals Guyana's ability to help save the Earth by sucking in the harmful gases like carbon dioxide, which destroy the planet. Guyana's forests store some 19.6 billion tons of carbon dioxide, and it wants to make money, lots of it, from that carbon. How does that actually work? Well, the carbon is used as sort of a bargaining chip for companies in countries whose activities, such as industrial plants, release the harmful carbon into the air. When that is released, it is breathed in by the forest. So Guyana's argument is pay us for taking your harmful gases out of the air. Guyana has crafted some prices for its carbon. For the years 2016 to 2020, it is charging some $15 per ton of carbon. For 2021 to 2025, the cost increases to $20 per ton, and for 2026 to 2030, a price of $25 per ton. Added together, that's a lot of money that Guyana can make. But this effort to compensate forest-rich countries has been long in the making for Guyana. Guyana has been up and down the United Nations and other fora arguing it could do like other countries and cut down its forests to make money from, say, timber or large-scale agricultural projects, but it isn't doing that.
In market data for oil rebounded after 4 sessions of decline, boosted by hopes that easing anti-COVID measures in China will revive demand and by signs that some tankers carrying Russian oil have been delayed after a G7 price cap came into effect. Brent crude rose 27 cents to $77.44 a barrel, while West Texas Intermediate crude gained 49 cents to $72.50. And that was the business report on PBCJ. I'm Denita Rodney.
In regional news, Cuban President Miguel Diaz-Canel, accompanied by a high-level delegation, arrived in Grenada on Wednesday as part of his official Caribbean tour.
As well as the arrival of our Honorable Prime Minister Dickon Mitchell, Foreign Affairs Minister Joseph Andel, and other cabinet ministers. Both sides were engaged in a closed-door session, which lasted for just about 2 hours, following which they engaged members of the media in a brief press conference. Prime Minister Mitchell disclosed to members of the media some of the areas that was discussed in the closed-door session, and some of that included education, climate resilience, healthcare, among others.
Today's discussion focused on our areas of collaboration, ranging from healthcare to infrastructure, to education, to agriculture, to the environment, climate change, and the need for us to build climate resilient and sustainable societies in the future. Both parties committed to continuing to collaborate and to work together and to strengthen and deepen our bonds of friendship.
Excellency Miguel Diaz-Canel expressed his appreciation to the government and people of Grenada for their accommodation since landing on the island earlier today.
This visit today represents an old yearning on our part, and the warm and transparent discussions we have held today have only come to confirm the necessity that we visited with you. And this visit also has a little bit of magic, for it is occurring at a time in which we are marking 50 years of relations between Cuba and 4 Caribbean countries.
In the Bahamas, in his first local exclusive interview, founder and former CEO of the now imploded company FTX, Sam Bankman-Fried, says he's still struggling with the events that led to the downfall of the Bahamas-based crypto exchange.
The 30-year-old, who had a net worth of billions just a month ago, acknowledging recently there was a borrowing lending facility at the cryptocurrency exchange, but did not know of deposits to pay its affiliated trading firm, Alameda Research. The relationship between Alameda and FTX, now known as the root cause of his downfall. We recently learned that $10 billion of FTX customer funds were moved to Alameda Research, characterized as a secret. In this exclusive chat, which airs in an hour-long special here on RTV at 8 o'clock Sunday night, Bankman-Fried admitting he did a pretty incomplete job at managing risks at FTX, but still insisting he had a plan to move the company forward. Take a look.
You say the company is still very valuable and could have been saved. How so?
Yeah. So before the filing, there were lots of parties who had indicated significant interest in billions of dollars of financing for it. And, you know, this had been a $40 billion company a month earlier. Even after the crash, there's a day where it traded $15 billion of volume, I think. So it was a valuable business, and most of that had nothing to do with what caused the crash. That was not an integral part of what made FTX a valuable business.
Who were some of those parties you mentioned who were interested prior to the collapse?
There was a wide array of them, and I don't know which of them ultimately would have come through. You know, these were all discussions, and I felt like I didn't have a lot of time. I think I had more time than I thought I did. I think I got some very bad legal advice.
In St. Kitts and Nevis, renewed effort on the environmental protection is now possible with the launch of the St. Christopher and Nevis Conservation Foundation on December 3, 2022. More in this SKN report.
Representing a collaboration between the public and private sectors. Initial focus will be on the St. Kitts Forest Reserve and conservation on the Nevis Peak. According to Brenda John, chairperson of the SCNCF, the foundation provides an avenue for small projects that together result in significant advancement in environmental protection on St. Kitts and Nevis.
It is the opinion of the SCNCF that an opportunity to collaborate on a meaningful project with small interventions by everyone could create the impact we all so desperately need. For that reason, the SCNCF today launches its pilot initiative named, and I don't want you to run away when I say the name, it's Enhancement and Conservation of Local Carbon Sinks. This project invites government agencies, non-government organizations, and businesses to submit proposals that will advance the work of revitalization, expansion of use, and development of policies to manage the Central Forest Reserve in St. Kitts and Nevis. Central Forest Reserve in St. Kitts and the Nevis Peak, which I assume everyone knows is in Nevis. The possibilities for inclusion by all eligible stakeholders is expansive. The SCNCF has put in place a management system that allows entities that would otherwise not have qualified for grant funding because of their organizational structures or the lack thereof, can apply under special guidelines. The success of this initiative will be demonstrated by, number one, more stakeholders engaged in meaningful environmental conservation, number two, enhancement of the Central Forest Reserve and Nevis Peak, and thirdly, development of policy guidelines.
In expressing support for the work of the foundation, Dr. Joyelle Clark, the minister with responsibility for the environment, said it was important to update environmental legislation passed decades ago to reflect the current realities, inclusive of livelihoods now dependent on tourism and environmental tours.
In Trinidad and Tobago, Chief Secretary Farley Augustine is making it clear that there will be no elections in Tobago despite calls from Watson Duke and the People's National Movement.
So no election? No elections.
A firm rejection from a Chief Secretary who has chosen to part ways with his political party. Not only that, Farley Augustine is also standing firm by the decision of his executive, citing strong legal advice.
Extremely legal. Any lawyer who is mooting anything other than that needs to go and double check their legal credentials. It's extremely legal.
He explains that the people of Tobago voted for a candidate before a political party.
And morally, we campaign that Farley will be Chief Secretary. We campaign that this will be the team. That does not change. The only thing that has changed is that we choose not to be identified by that name called PDP. That's all that has changed.
But while the THA executive remains independent for now, Augustine tells the CNC3 News they are seeking to form a new political party.
So there are plans to form a new party? Well, there are plans to engage the public and have the people in Tobago participate in forming what that will look like.
He says they will start that conversation in January 2023.
Russia has released U.S. basketball star Brittany Griner in a prisoner exchange. U.S. and Russian officials have made that statement. Russia said she had been traded for Victor Bout, a Russian arms dealer jailed in the United States.
The two-time Olympic gold medalist was arrested in February and sentenced to 9 years in prison in August. She was convicted of smuggling and possessing cannabis oil. Let's go live now to Moscow. Al Jazeera's Ali Hashim is there. Ali, tell us more about this release and what Russia's foreign ministry is saying about it.
Yes, Adrian, Victor Bout, the Russian arms dealer, has been swapped to the U.S. basketball player Brittany Griner, and that took place in Abu Dhabi's airport. This is what the Ministry of Foreign Affairs here in Moscow said, that the Russian national has been extradited, or at least swapped, with a basketball player who was imprisoned here in Russia. This is the only line we we read from the Ministry of Foreign Affairs that said that more information is expected to be announced in the coming hours. However, this swap comes only 24 hours after a phone call between the Russian President Vladimir Putin and the President of the Emirates, Mohammed bin Zayed. This we can put this into context, whereas since this swap took place in the Emirates, in Abu Dhabi, then this Emirati role was clear in the swap operation. So this is all what we know till the moment. We are waiting to know when Victor Bout is going to arrive here in Moscow, especially that the whole thing happened away from media. Now everyone is knowing about this because it's being announced. However, the swap took place, and each of the prisoners went to their country. We don't know if the Russian national has already arrived in Moscow or not. This is to be. He already arrived. Now I know that he already arrived in Moscow. So he's now in Moscow, and so the whole operation took place and it's complete.
And what do we know about this man, Victor Bout? He was an arms dealer, right?
Well, what we know about him is that he's a Russian, he's an arms dealer, and he was arrested in the U.S. and was imprisoned there. He was serving a sentence in the prison.
In sports, it was a disappointing day with the bat for coach Courtney Walsh and the West Indies women's team as England women took an unassailable 2-0 lead in the CG United One-Day International by winning the second match by 142 runs at the Sir Vivian Richards Stadium in Antigua. Wayne Cunningham has the details.
The West Indies women put themselves in a position to square the series when they had the visitors all out for 260 in 48.1 overs. 17 not out from wicketkeeper Amy Jones was the top scorer, with Sophia Dunkley contributing 57.
4 runs.
3 other English batters got into the 20s but could not carry on. Hayley Matthews led from the front with the ball, the captain taking 3 for 50 from 9.1 overs. Affie Fletcher had 2 for 41 from 10, while Aaliyah Allen also took a pair in her 8 overs, which cost 47 runs. Although the score seemed gettable, the English confidence of victory was still high, mainly due to the fact that the host has not crossed 200 in their previous 9 one-day international innings. That trend looks set to continue when Lauren Bell had the dependable Hayley Matthews back in the pavilion with only 7 balls bowled. Bell also accounted for Kaisia Knight in the same over.
Has she got bat on that one? Yes, she has. It's another one.
And when Aaliyah Allen fell in the very next over, bowled by Kate Cross, the West Indies were reeling at 3 for 4 in the third over. 54 not out from Rashada Williams was a shining light in the home team's innings, but the spiral continued as they could only muster 118 all out in 31.3 overs. The 21-year-old Lauren Bell ending with figures of 4 for 33 from 8 as England takes the series with a game to spare. The teams meet again on Friday, December 9th at the same venue for the third CG United One-Day International in a day-night encounter. First ball is at 2 p.m. Eastern Caribbean Time. Wayne Cunningham, TTT Sport.
Trinidad and Tobago is now the home of the first satellite center in this part of the world at the National Velodrome in Cova. This after the official UCI launch on Saturday.
After 6 years of hard work and diligence, the Sports Company of Trinidad and Tobago, in collaboration with the Trinidad and Tobago Cycling Federation, has successfully cemented an alliance with the Union Cycliste Internationale to be the only satellite center in the Caribbean and the Western Hemisphere. Minister of Sport and Community Development Shamfa Kujo was over the moon on this achievement.
This satellite center accreditation signifies that our very own cycling velodrome here in Balmain, Cova, will be a hub for athletes from our region and beyond to train and to hone their skills rather than having to take trips to Switzerland and to other distant places to pursue their athletic aspirations.
Being accredited with this high esteem means that athletes can carry out improvement works when it comes to detection, training and preparation to pursue cycling at the highest level. The center will also give individuals the best training possible for those wishing to work in cycling-related fields. TNT now joins South Africa, Japan, India and Portugal as the only other countries with UCI-accredited satellite centers, and Minister Cudjoe noted that the seeds have already been planted for other sporting facilities to receive equivalent world recognition.
Trinidad and Tobago is on the move, working to bring honor and glory to sports, to our nation and region by extension. It's not only hard work, it is also hard work. So rest assured that the rewards are many in this labor of love.
The official plaque reveal was done by Minister Cudjoe, TT Cycling Federation President Rowena Williams, Member of Parliament Rudranath Indar Singh, board members of Sport TT and several dignitaries from the various international governing bodies.
And that's the news on PBCJ. Thanks for watching.
The hurricane season runs from June 1 through November 30. It normally peaks between August and October. Be prepared.
Lightning have been known to strike during a storm. Lightning can travel through your home's plumbing system and give you quite a jolt. Stay out of the shower during a storm. Avoid washing dishes as well. Monitor your radio or television for weather updates and instructions. Be prepared.
Every Jamaican has the right to know what is happening in Parliament, to know when new laws are being passed, and to give their opinions on legislation before either house.
Every Jamaican has the right to see their representatives in action, making laws, holding the executive to account, representing the people, working for the benefit of all Jamaicans.
It is your right to observe first-hand meetings of the Senate, meetings of the House of Representatives, and the meetings of parliamentary committees. You may also take a tour of your parliament.
To find out more about the Houses of Parliament, please call 876-922-0200, follow us on Instagram and Facebook, or visit our website at www.japarliament.gov.jm.
I am Paula Llewellyn, Queen's Counsel, the Director of Public Prosecutions for Jamaica. We are in an era which focuses on all things technological. As such, material produced by all sorts of devices, including computers and phones, is increasingly becoming a central feature of criminal investigations. Good prosecutions are based on the fruits of good investigations. It is therefore critical that police officers who are engaged in investigations which involve the collection and examination of evidentiary material are equipped with the necessary tools which will enhance their capabilities in respect of securing the preservation of data and obtaining the production of the said data for court purposes. The Jamaican Cybercrimes Act of 2015 contains search and seizure provisions which are available and allow the police to enter any place named in the warrant to search and seize any computer material which would be reasonably required to facilitate and progress the criminal investigation.
Such computer material includes any data which may consist of
video footage stored on closed-circuit surveillance systems, CCTV, or data stored on global positioning systems, GPS. Also, photographic images or any other material which may be stored electronically on any storage medium. It can also include call data records or cell site information, provided it is material which is stored electronically.
Firstly, and most importantly, police investigators must be aware that computer material cannot assist if it is not preserved at a very early stage in the criminal investigations. Preservation is critical. Computer material is transient. It can be easily deleted or rendered inaccessible to the police. Therefore, after carefully analyzing the crime scene and/or the allegations, investigators must seek to identify all items of digital evidence which may be useful in proving the commission of an offense or which may also serve to identify a suspect. Once you have identified them, you are encouraged to expeditiously seek to preserve them.
In this video, we will explore the tools given to the police under the Cybercrimes Act of 2015 to compel a citizen to preserve computer material which is reasonably required for a criminal investigation. The tools available to facilitate the production of such computer material in an intelligible form, as well as the search and seizure powers which are available to the police under the legislation.
It's a warm summer day. As young people often do, David and Wendy, who are on an afternoon stroll, decide to take a few pictures and a vlog for posting on social media. Cara, who is focused on getting to the bank on time, unwittingly walks into the vlogger's shot. These seemingly random set of events are critical to what happens next.
Miss Wendy, what happened here?
Honestly, officer, a bad thing gone right now a while ago.
What happened?
It's a maga man in maga bad, in about this tall, like 6 feet tall, and his face bleach out. It's a bleach out face boy.
Officer, I know so the man look, you understand? I don't know what you're talking about. In about my complexion, you understand me? And him about 6 feet tall, him about 5'7", and him belly did big. You understand? Belly did big.
Did you identify the vehicle?
Yes, officer, yes. It's a blue Probox. Yeah. I'm see the license plate number. Here's the 5525ZZ. Clear,
No.
officer, clear.
Officer. Honest, all right? Listen, officer, shouldn't know nothing about here, all right? You don't know nothing, all right? It's a black Nissan Figa, all right? Not even the license plate you get right. It's 5255ZS. That is what was there.
There are clear discrepancies in respect to crucial descriptions of the perpetrator and the vehicle. The question is, how best to resolve these discrepancies? The officer asks if there are any other witnesses who could better assist. Suddenly, David remembers that he captured the event on his cell phone. He plays the video for the police officer. After viewing, the officer is sufficiently convinced that the video is crucial evidence in his investigation. He therefore instructs David to head to the police station to give a written statement and to allow the team from CFCD to extract the data from his phone.
My phone?
But David refuses and the officer insists.
No. With all due respect, we're gonna deal with the courthouse and police station and them thing, worse. Me and my phone, no sir.
There's no need to worry. It's a safe procedure. and you will be okay. We just want to get information from the phone.
But officer, I don't show you the video. That not help you.
It's nothing to worry about, man. I insist, we need information.
No. Alright. You look like a person who want to press me, so here what? If a person who want to press, I might as well just delete it.
No, David, you cannot delete the information. If you do, you can be charged. It's an offense. You may pay a fine of $3 million or go to prison for 3 years.
In a situation such as this, a preservation notice under Section 17 of the Cybercrimes Act could be prepared expeditiously and served on David immediately. This notice must be in writing. What is the effect of this written notice? This written notice compels persons such as David from altering, manipulating, or destroying the computer data which is in their possession or under their control, and which is reasonably required for a criminal investigation. This notice can be used for any criminal investigation. This notice must include the name of the person who is in possession of the data, as well as an address which can include a physical address or an IP address, email address, or telephone number. This written notice expires 60 days after the date of service. If an officer needs an extension beyond the 60 days, an application must be made before a parish judge. If David deletes the footage after a preservation notice has been served on him, he can be prosecuted. If convicted, he could face a maximum fine of $3 million or 3 years imprisonment. In this case, David, on seeing the notice for preservation, decides to hand over the phone. However, what if David does not hand over the data? After serving the preservation notice, the officer may seek to utilize another tool which is available to him under the Cybercrimes Act of 2015, a production order. This is an order compelling David to produce the data in an intelligible form.
It has been 3 weeks since Kara's excruciating ordeal. One which she did not disclose to anyone because of her embarrassment. Since the incident, she has been struggling with depression and self-deprecation. She is jolted from her trance by an alert on her phone. She does not recognize the number. After receiving the nude photograph that was taken of her, Kara begins to relive the heinous sexual assault that was perpetrated upon her 3 weeks ago. Kara notices that the person who is contacting her is the same person who kidnapped, sexually assaulted her, and caused others to sexually assault her. He debases her further with cruel taunts. To add insult to injury, he proceeds to extort her. Based on this most recent act of degradation, Kara finally builds up the courage to report the matter to the police.
Hello, I'm here to report a rape. Here's the person that did it.
Whilst taking her statement, the investigating officer realizes that she has to engage multiple sections of the Cybercrimes Act of 2015. In this case, she considers the investigative tools under the Act which may assist in securing any computer material needed for the criminal investigation. In this case, the investigating officer prepares an application under Section 18 of the Cybercrimes Act, seeking to obtain a warrant to search the home of ignorant crooks. She wishes to enter these premises to search for and seize the cellular phone or other digital device that contains relevant evidence which is capable of proving the commission of an offense. Under Section 18 of the Cybercrimes Act, a parish judge may issue a warrant where he or she is satisfied by information on oath that there are reasonable grounds to suspect that either there may be computer material in any place which may be relevant as evidence in proving an offense, or where such computer material was acquired by a person for the purpose of, or as a result of, or during the commission of an offense. As indicated, the application for a search and seizure warrant must be supported by information on oath. This means that the constable must either prepare an affidavit in support of his application or swear on the Bible and give true answers before the parish court judge. In this case, the police prepare a written application supported by an affidavit. They go before the parish court judge and make an application for a
the representatives of the JCF here. So in the interest of time, I'm going to move to Mr. Luars. Where is his presentation? It's a single screen.
No. Testing. I don't know. Is the mic on?
Would you help us by just introducing yourself? And
Okay. Madam Chairman, members of the Joint Committee, it's really my pleasure to have this opportunity to speak to you guys. I appreciate it, and I really looking forward to share my views from a layman's point of view. Sitting here this morning listening to the academician and the professionals kind of take me back to the simple man in the street. My views today are basically from the layman perspective, and as such I won't be quoting or in any way selecting any section or subsection of the Act. I leave that to the my learned professionals, which I believe they have done a good job so far. Just to mention who I am for the benefit of the committee. My name is Royston. Most people call me Tony Lewars, and I'm from a very remote village or community in northern Clarendon called Brayhead, which I doubt any of you guys have heard. Brayhead.
Brayhead?
Yeah.
How is that spelled?
Braehead. I'm a past student of...
Well, you do have a member of parliament here.
Yeah,
not here in the House, but every community.
It's a siblings here.
Yes.
Yeah. I'm a past student of the Doncaster Cup champion Clarendon College, and I've spent over 30 years in the United States, and I returned for the past 3 to 4 years. And I'm now in my community where I serve as a chairman of my primary school board, and also I was recently appointed a JP for the parish of Clarendon. Two things trigger me to make decision to add my 2 cents to this debate in terms of the bail hack. One was my recent training in the JP training in Clarendon. And secondly, it was due to my extended experience as the president of a NAACP, which is the National Association for the Advancement of Colored People in America. I've been president for around 6-7 years, and I encounter a lot of bail ban issues during my term of office. So I felt that, you know, Jamaica experienced such similarity. I would be remiss if I didn't say something about it. I believe the original purpose of offering bail was to allow someone charged with a crime to remain free until the trial date, while ensuring that they would show up at the trial. That being said, I don't believe that bail was ever intended to serve as a punishment for the defendant. It was based on the simple principle of one being presumed innocent until proven guilty. Unfortunately, today bails appear to serve as a punishment of the defendant before a verdict is reached. The outcome is most evident among the poor, the illiterate, the less fortunate among us. With significant improvement in technology and communication over the past 40 to 50 years, I truly believe that if we still hold good to the original purpose of offering bail, then cash bail should be made redundant and be placed among the many other obsolete victims of technology. Today, cash bail only serves to enrich bail bond agency while creating undue hardship to poor defendants and their families. There's a tendency to go back in history and rely on the past precedent. No doubt some past precedents are fundamental to our history and have served us well. However, at the same time, a significant portion of past laws were not only morally wrong, but legally flawed in the eyes of today's legal expert. A typical example I can mention is slavery, which was once the law of the land in several countries, and yet how wrong it was, but was still defended for centuries. I said all this to say that in making and revising our law, we have to make them practical to the current norms of society. We can no longer be focused on narrow self-interest. Instead, the law should make everyone feel that it applies to them equally. I don't believe in any of us who took the time to make a presentation here ever feel that it applies, of our opinion, believe that we're going to get a perfect bail hack. However, at the end of the day, we would like to know that there is a level of comfort to the hack that makes both those who administer it and those who benefit from it feel good about it. I am in support of increasing the holding time from 24 to 48 hours, which is basically very practical in today's operation of the justice system. I am not comfortable with a significant portion of Section 5, but then again, the legal and the academia have mentioned enough about it, so there's no need for me to repeat. One of my main concerns is the Act does not address any remedies for administrators who knowingly breach the requirement of the Act. I say this to say that there have been and will be many defendants who are taken into custody, not charged within the stated timeline, and are knowingly left to suffer in jail for an extended period because the officer in charge failed to do the right thing. Can we continue just to let things slide while the innocent suffer? Most defendants don't know the law and their rights under the law, so they end up being victims of their own ignorance. When those in authority fail to do what is right, should we continue to ignore their action? My second concern is the bail is seen as a punishment by most people. The Act doesn't give any clear option for a poor or at-risk defendant. Although everyone in the system may even agree that a defendant does not belong in jail, there are still tied if the individual just can't afford to come up with their minimum bail. My contention is, it is just wrong for innocent defendant to be held in jail for days, weeks, months, and even years based on past history because they can't afford bail. I'm not opposed to bail for proven high-risk criminal or their defendant who are obviously guilty of a serious crime. However, there should be a clear line of demarcation that separates the type of defendant. Let's not talk it, but let's practice the assumption of innocence until proven guilty. Bail is not a fine. It is not supposed to be used as punishment. The purpose of bail is simple: to ensure that the defendant will appear at trial. So be the case, let's utilize all the technology that have come forth within the past years. In closing, my question to the committee is simple. Is the purpose of bail still to ensure that the defendant show up in court at the appointed date and time? Or are we using it to punish poor and most time innocent defendants? Are we effectively using the technology at hand to ensure defendants show up at courts? Or are we stuck in the old ways of doing things? Thank you for listening to my simple views, and I hope they serve as food for thought as you finalize the hack.
Mr. Luars, may I just tell you how very pleased I am that you have taken the time to come all the way from Braehead, Clarendon, to share your views with the committee. You should never underestimate what you bring, even as a simple layman, to borrow your self-description. I think you have raised important issues. And it is true that the grant or denial of bail is viewed in many quarters as an instrument of reward or punishment. And that really is not how properly it should be viewed, but it is the reality. And I know myriad emotions are evoked on this issue. You have provoked an important issue in your question and your comment about holding to account those who breach the provisions of the law. I can tell you that it is an issue that I personally grappled with during the policy development stage. And I say without equivocation that I am strongly of the view that, notwithstanding what is currently provided for in the law, it is something that we will have to look at again and sooner than later. The question was whether the bail bill was the appropriate place to deal with it. And the answer that those of us who looked at it came down on was that the bail bill would not be the place for it. But it doesn't mean that in an appropriate case where the conduct of any deciding officer is brought into question, or any arresting or investigating officer, that other matters may not flow from it. I am strongly of the view that we have to look at those who discharge functions and exercise powers on behalf of the state, and rethink how we deal with them, treat them from the perspective of the implications of their actions. If it is any consolation to you, I do share the view that we have too many examples of those who are disadvantaged, whether economically, socially, or in any other category, who have experienced injustice in the formal criminal system. And to the extent that the Parliament's power is to pass laws for peace, order, and good government, we have to do everything in our powers to ensure we do not have a repeat. You cited slavery, an extreme example, but a good one. And as I've said before, I count it a blessing that we come to these deliberations with much to learn from and a lot of guidance. You've expressed generally your discomfort with aspects of Clause 5, which sets out the pre-charge regime. And because it is true that the flip side of pre-charge is pre-detention, because if bail is not granted, you can be detained. But I think because of the emotions that have been understandably evoked, some may be overlooking the justice that we're seeking to achieve in the provision, and to ensure that that each case is assessed on its own merits and in its own circumstances. And where appropriate, as a general rule, persons who are lawfully and constitutionally deprived of their liberty on reasonable suspicion that they have committed an offense, that they do not languish in custody because the state, through its agents, fails to act in a timely way. We recognize from a policy perspective that there are multiple goals to be pursued in the interest of justice. And I think, notwithstanding any views that we have, there is a proper place for investigations to be carried out in a Jamaican society where witnesses and victims are sometimes part of the criminal enterprise, where witnesses are reluctant for any of many reasons, where they are intimidated and threatened, sometimes even killed, because we have many examples of that. And so no single piece of legislation will achieve all of the justice goals. And no single piece of legislation can address all of the genuine concerns that arise. And so part of the work, and in particular, the work assigned to the Ministry of Legal and Constitutional Affairs, is to help to educate. And a big part of educating is providing opportunities for dialogue and exchange of perspectives. And it is my hope that this process, and in particular this process of the Joint Select Committee, but this particular one on the bail bill, will provide that opportunity. I do not see any hand raised from members of the committee, but this is what I've longed for, to see an ordinary citizen getting an invitation, taking the time to come. So I want to thank you. I want to thank you.
You're welcome.
You are free to remain if you choose to do
thanks.
so. And may I congratulate you on your recent appointment as a Justice of the Peace. And you would know that in that category, you will have a role to play. Member Williams?
Just an inquiry, Madam Chair. Is Mr. Loir's submission in writing? Is there a copy? Oh, very well, very well, very well.
In via email to the clerk's office. All right. Is the purpose of bail still to ensure a defendant show up at court for trial? It's not a single purpose, but it is one of them, and I can answer yes. Because the goal of ensuring that you surrender to custody, that is the objective that this question falls in, and you would have seen that it is specifically provided. And what we have done is to ensure that any condition of bail imposed is imposed with a view to achieving the goals that the case law says are legitimate pursuits using bail. All right?
Madam Chair, in relation to there is reference to cashless bail and the question of surety, and we know we have that problem of, in the layman's terms, the bailman. I am somewhat encouraged by Section 16, which, in a sense, makes it more probing, of person's character who come forward as surety. So Section 16 of the Act, if you look at it carefully, Mr. Lewis, we are seeking to ensure that the persons who put forward themselves as surety have a threshold or a standard to which they have to attain, rise up to. Thank you.
Thank you for that, Member Williams. So this law addresses a lot of the concerns raised around the provision of surety. Like I say, we may not be able to deal with every aspect of it, but one of the malpractice is where persons enter into agreement to be indemnified, to provide, to act as surety. And, when I looked back on the research, there was a time when I think, by way of statements made, a proposal was given, was put forward for the bondman industry to be developed. But what we have seen is that the way it has been practiced is not, the evidence shows it's not so much about furthering the goals of justice, right? And the incentives have been very different. So that take time and just look at that provision, and you would see that some of the concerns have been addressed there. Yes, we did also consider how payments are to be made, having regard to what is in the current law, where a bond is to be provided. But just bear in mind that what the law does, where surety is required on an assessment, is to enable, in an appropriate case, the defendant himself to provide it and to make it easier for him to do so by not only requiring real property. And you would see in the law how the bond is to be treated, how it can be forfeited. And I believe we try to be as fair as possible, how you can be relieved, even on your own application, depending on the circumstances, and when automatically you are discharged of the responsibility when the case comes to an end at different juncture. So, for example, if it is terminated by the Director of Public Prosecution by entering what is called a nolle prosequi, nullifying the prosecution at a certain point, where the person is either acquitted or convicted, where the case is dismissed, etc. So we have considered it carefully to ensure that we strike the right balance for those who come forward with the right intention. So the law does not presuppose that everybody who acts is doing so with male fides. We give the benefit of the doubt. we give the benefit of the doubt. That's why I have been saying to persons, read it fully and carefully, please. But we understand that we have a tendency to talk around the issues because there's so much grievance around the issues that sometimes we forget that when a law is passed and it goes to court, it's not how you feel about it, but it's actually what is contained in it that the court will seek to interpret. So again, thank you for participating. You're welcome to remain. I still see no hand from members. All right, so Ms. Golding, we will go back to the JCF and then come back to you. All right.
Good afternoon again, Chairman and members, guests who are making presentations like us. A pleasant good afternoon, and I just want to state here that the JCF is grateful for the opportunity to present.
Please just indicate your name
I'm
for the
so
record.
sorry. I am Ariel Brown Blake, and I appear on behalf of the JCF. With me, Superintendent of Police Dwight Daly, as well as Miss Tishana, that's Miss Tishana Maxwell, legal officer. To continue.
I was just looking to see members of the committee who are still with us virtually. Yes, please proceed.
So we're grateful for an opportunity to present in this forum. We had the opportunity on previous occasions to make contributions or submissions through the Ministry of National Security, but those were behind the scenes. And we had made, I guess, more lengthy submissions on those occasions. So I just want to explain why our submissions this afternoon are so brief. We really won't take much of your time, certainly not like Mr. Williams. Right. And I agree with you, Sir Williams. It speaks to the efficacy of the bill. And I want, although our submissions today don't examine pre-charge bail because we considered it on all those occasions that we had in the past, I just want to state at this juncture that because of the understanding of the Jamaican criminal context that we have as members of the JCF, we find the implementation of such a provision to be one that is not just, I don't want to say that it is good or it is timely, it is critical. And we support its implementation because we understand the reality that the balancing of a person's right to liberty is important and is necessary. But we also understand that on that scale, the other side of the scale, there needs to be a balance of how we deal with and how we treat with impending harm. And also giving the police an opportunity to put their case file together. And in our opinion, and in our thorough examination of the bill, we find it to be one that properly achieves that balance. And that's really the sum total of my discussion today.
Persons listening will say that's a self-serving view of the JCF.
You know, I wouldn't say so, but on previous occasions, we submitted data. I don't have that data before me at the moment because the submissions that we have here treat on other matters. But we have been in the position to submit that kind of data, which reflects the necessity of such a provision. So to say it is self-serving, I understand why that might cross the minds of others. But indeed, when you are, there's a little saying, who feels it knows. So when you are in the possession of such data and you are in a situation to examine the data in a critical way and in an informed way, you will understand the need for such a provision. I want to reiterate that our submissions are brief, and I move to start them now. Superintendent of Police, Sir Dwight Daly, will also address some of the submissions herein, and we will commence now. All right. This paper that was distributed, what it really deals with is recommendations that we would have made on previous occasions, as well as areas of concern to us in the bill where we think that there should be additional offences. Relative, and if you have the paper to follow along, I will start at paragraph 2. And relative to the inclusion of pre-charge bail in the bill, there is no mention of what happens should a person on pre-charge bail fail to adhere to the conditions of bail. And so we want to take this opportunity in writing to reiterate our recommendation that a breach of pre-charge bail conditions should be made an offence in the bill or in the Act.
We say we had considered that and decided not to make it an offence.
Very well. I don't know if you want to elaborate on that, or we'll do so in another forum.
So again, it was kind of balancing. Yes, having regard to the fact that we're actually dealing with the stage between the arrest and detention,
right,
and the charge to be preferred, eventually leading to trial within a reasonable time. We felt that though in the scheme where a failure to comply with a condition of bail has consequences, we wouldn't put it at this stage.
Yes, Madam Chair, but if there is no consequence, why would the persons comply? If they can just not comply and there is no consequence.
Make your case. Make your case, JCF, make your case.
Well, if we don't want to impose a breach at that level, could we then take the matter before a judge and then advise the court that this person is not complying with the conditions imposed by the police or the JP, and then the court now could reimpose those conditions, and then if those conditions are breached thereafter, then it could constitute an offense.
Just provide for appeal in respect on both sides, and importantly in respect of conditions imposed or not imposed. Let me just pull it up. Ms. Wilkins, can you just pull up that part of the provision for me? But please go ahead. Perhaps we will just take the submission first instead of the back.
Very well. We note that the bill contemplates some additional restrictions on the grant of bail to persons charged. And we see this in the second schedule, parts 1 and 2. However, we note that certain very serious offenses that are prevalent and that contribute to the high rate of crime and violence in Jamaica are still not contemplated as offenses.
Sorry to pause.
Sure.
Please look on clause 11 and 12. In respect of the point that was raised before. And just to say, as I said before, there is a printing omission in the part 1 of the schedule where the firearm offences were omitted. A printing omission. So I think that's probably what you're addressing. Yes.
Indeed it is.
Right. So those offences that are set out in part 2 in respect of the firearms, they actually should have been in the part 1, but a printing omission left them out. So we have already flagged that.
Grateful. Thank you.
I don't know if that answers the point that you were about to raise.
Yes, it does,
Okay.
because we saw those omissions.
Right.
We also, but still, not to belabor the point, but still on that point, we also listed offences under the Larceny Act, as well as offences for the kind consideration of the committee under the Proceeds of Crimes Act. And so you have them there just in order for this submission to be brief, you have them there outlined. So we are asking for a consideration to be made for those because the statistics that we have show that they are indeed a major contributor to the high rate of crime and violence.
We have predial larceny under the Larceny Act, and we have extortion under Section 42A, because that issue was raised with us. And I believe those are the targeted ones. At least that is what the data that we assessed, it was in that field. So the predial larceny was presented to us as an area that facilitates the organized crime a lot.
Right, indeed.
Right, and then the extortion issue. And that's included. Look at item 4 of part 1. Second schedule. Page 29.
I see those, and it does address two things that we have here, but we listed 2 other offenses as well as the offenses under POCA for your consideration.
2 other offenses?
We have section 37, which is burglary. We have, that's section 39, which is burglary. We have 40 and 41, which is housebreaking. One is housebreaking and one is housebreaking with intent to commit felony.
2A is included.
Yes.
I know there was some recommendation about receiving, which is the lesser offense to larceny, because the POCA schedule, I think, was, or the anti-gang, was amended to include that one, arising out of one of the cases that was prosecuted in the courts.
Yes, yes.
So you would be asking for that one also?
Yes, we would.
So in the scheme of things, it is categorized as a lesser offense, but we are mindful that the evidence on the ground and the data shows that albeit a misdemeanor, it is a facilitatory offense.
It is.
And provides a foundation to the gangs and the criminal element to do a number of other things. So we can note it for policy consideration for inclusion after deliberation. But yes, we did assess the data in respect of receiving, and in particular how it had played out in the one of the major cases before the court and the subsequent amendment that was done to the schedule, albeit that it was not categorized as a major crime, but how it operates. Yes. That one is duly noted.
Thank you so much. And just one more under larceny for your consideration, Madam Chair, is 37, which is robbery. All right, to continue, relative to identification parades, we note that section 5(1)A allows for the question of bail to be considered within 48 hours where a defendant has been arrested or detained but is yet to be charged. Section 5(3) of the bill continues to require a defendant to be brought before a judge within a 120-hour period where it is that an ID parade is required. In the event, however, that an ID parade is not held within the 120 hours, which unfortunately is the case sometimes. You know, we have resource issues, staffing issues, so there are various reasons why 120 hours may pass and the ID parade is not held by the VIU. Right, witnesses inaccessible, yes, which is a key one. So many reasons, right? We are submitting that the requirement to be brought, well, we have noted that the requirement to be brought before the judge still remains. And if they are brought before the judge, it has serious implications on the integrity of the process, because the identity of the defendant being released prior to such an ID parade can give a witness an opportunity to have sight of the defendant prior to the ID exercise, which of course opens the gates for defense counsel to challenge the integrity of the process.
Right. So it's one of the provisions that I discussed with the CPC, actually. So what you would see is a carryover from what currently exists.
Right.
And I think we inadvertently missed a little thing. So when persons hear about increased time, they get very nervous and they think that it automatically equates to trampling on the rights of a defendant. But the point you're raising is important, because the interest of justice is not served if a suspect is compromised and an opportunity is presented for someone to see that suspect before he or she is identified on a parade. I think many don't fully understand that the time given behind the scene to ensure that the administrative requirements necessary to put the ID parade in place, that time is used, and that it is more than anything else to protect the suspect. Because a critical ingredient of the crime, of proving any offense, no matter how outraged, is whether the defendant before the court is the one who committed the offense. So identification is always a critical element. But again, the data that was presented to us told us that the JCF does not struggle in the same way that it struggled in the past to do ID parades, and in fact there is an easy and improved way. So the reason why the time frame is set to the extent that it is to take into account cases where you have multiple defendants and you would have to arrange a parade in respect of each. And that too requires getting the witnesses, because there can be no pre-conclusion that is the same witness that it identifies. But yeah, we'll have to look at it. We'll have to look at it, because you don't want any harm to be done simply because we're concerned about enlarging the time, because the interest of justice is never served in having a suspect exposed so that an allegation can be made that it was a deliberate exposure to say to a potential witness that that is the person who's to be pointed out on the parade. And during my times in the criminal court, there were many concerns raised along this line, and we don't want to be back in that space. So tell me this recommendation again.
So our recommendation is for one, that there be a consideration in the bill for or an implementation of a provision for after the 120 hours or upon the 120 hours being reached, that the suspect, or the defendant rather, be brought before a judge in chambers so that their identity, so that the matter, I'm so sorry, not that the defendant be brought before the judge in chambers, but that the matter be considered before a judge in chambers. We recommended here also that provision section 22 of the current act be carried over, and you spoke of the carrying over of the current act, and section 22, it provides for where an ID parade is required in relation to that person, the person shall not be brought before an RM or a JP, but the matter shall be referred to an RM or a JP who shall make any such order in the absence of that person. So our recommendation is in line with what the current act is saying. We're not asking for the defendant to be moved, but for the matter to be considered in the absence of the defendant, preferably in chambers.
Yes. we had already flagged this as a clause that we would have to revisit. So thank you. Just to point out that there are other innovations in the justice system now, and not all defendants are brought face to face. So the risk of improper exposure can be mitigated and perhaps eliminated because virtual hearings and there are creative tools that are used. So you would have seen that we made reference to the rules of court. And the rules of court have been changing to take into account certain realities, and especially utilizing technology coming out of COVID. So we noted this one for consideration. Committee will deliberate.
Guided and grateful.
What is provided.
To our next submission, we want to address the release of a surety. Sorry, I crave indulgence a moment. Right before I head there, just to slightly backtrack, we noted that should the provisions regarding the identification parade be amended in accordance with what we just discussed, an amendment to the Judicature Parish Courts Act may need to be contemplated, and that is section 63A, 3 and 4.
In the consequential amendment for the hearing of matters in chambers?
No, it was not done in the consequential amendments. So let me open that provision.
Because we did a consequential amendment at 67, section 67. For 67. In respect of any issue concerning bail.
Chair, I just need some clarity. Is it in order for it to be heard in chambers, you're thinking that an amendment is required? Oh, I'm not.
Right, because we would have provided for that. Yes.
We were asking for it to also reflect the 120 hours that the bill currently is providing, just to bring it in line with the bill.
Sorry, I don't have the provision of section 63 before me, but if you do, could we just have the benefit of it?
Really?
It says, the magistrate, so this is 63A, subsection 3. All right, let me start from subsection 1 just to give context.
So you know resident magistrate is read and construed as a parish court judge.
Yes.
Counsel?
Yes.
So you shouldn't be reading to me resident magistrate.
Creatures of habit, indeed.
Yes.
Counsel? Parish judge,
yes.
Guided. Good. I am so guided. A parish judge shall make enquiries at least once in every week into the case of each person listed by a member of the Jamaica Constabulary Force as being detained with a view to the holding of an ID parade. 2 says such member shall, in any such case, bring evidence to satisfy the parish judge that adequate steps are being taken to expedite the holding of the ID parade. Now on to sections 3 and 4. The magistrate may thereafter, A, remand the detained person for such further period as is necessary to conduct the ID parade, or B, if he is not satisfied that it is intended to hold an ID parade in respect of the detained person within a reasonable time, order that the detained person be brought before a court within 24 hours. And subsection 4 reads, where a person is brought before a court, as mentioned in subsection 3, the court shall make such order as it considers appropriate, having regard to all circumstances of the case.
24, sorry, I'll have to look at it, but thank you. Ms. Wilk, just flag it.
So it's saying within a reasonable time. If the person is not brought before the court within a reasonable time, then the person must be brought before the court, I think, within 24 hours. So we could maybe change a reasonable time to the 120 hours and take it from there to bring it in line with the bail bill.
But you know that the provision for within a reasonable time does not offend. It does not offend at all. Because reasonable time is determined having regard to the circumstances. I thought you meant that there was an actual delimitation of time that needed to be amended. But we will look at it. I mean, I can't make a pronouncement on it without the benefit of reading it, and also the committee would deliberate. But the gist of what you're saying is that you want to ensure there is no inconsistency between that provision and that. I thought we had looked at those provisions of the Judicature Parish Court Act that needed amendment, and that's why Section 67 is consequentially amended for clarity to provide for the hearing of matters pertaining to bail in chambers. Since the court...
Chair, it's just that though this person is going to be brought before the court within the 120 hours. So you're already, that time would already have been taken care of when you're in court addressing the matter. So then how then would an additional 120-hour period, I'm trying to figure out, but that period would have elapsed before you go to court.
We are saying if the person is not, if the ID parade is not kept or held.
Yes, and you have 120 hours. And that time has elapsed, and you're now going to court as subsection 3 would have required.
So that is saying that we are to take the person before the court within 24 hours?
120 hours. No, I'm saying based on this, it is at expiration or within a 120-hour period. You have that time before you need to take the person before the court. Or if the person is absent, bring the matter to the court. So that period would have elapsed. The judge then is going to assess whether or not, based on the facts presented, an ID parade is possible, feasible, whatever, within the period of time that the judge considered reasonable. And if it doesn't appear as if an ID parade is ever going to happen in any time that would be considered reasonable, then bring the person in 24 hours. So I'm just saying, we make sure we're not doubling up 120 hours.
To thank you for bringing the provision to 4, because it just reminded me that a lot of the concerns that have been raised about problems in the criminal justice system have been addressed over time, statutorily. And this particular issue of ensuring that adequate steps are being taken to expedite the holding of identification parade was at one time a sore issue, which led to this amendment providing for the judge to make inquiries at least once per week into cases where the police say the person is in custody pending an ID parade. And in fact, the provision even predates the Bail Act. These are amendments that came in the 1990s. I remember them from my time at the bar, and certainly when I just came to the bar. But on a quick reading, without getting into the deliberations of it, I am not seeing, on a quick reading, that any amendment would be required. So what the Bail Act says, no, on this point, what the Bail Act says is that it gives more time because more administrative requirements have to be complied with in order for an ID parade to be held. And in particular, it takes into account that you may have multiple defendants and that it would not be proper to expose the suspect before an ID parade is held. And so the time is given. So remember, the scheme of the law is that you have what is proposed is that within 48 hours of arresting or detaining someone, you have to consider the question of bail. If you grant it, that's fine. If you don't grant it, within another 48 hours, you have to bring the person before the court for the question to be considered. The time is enlarged where there is need to hold an ID parade because of what is required in setting up an ID parade. The concerns were that police in the past have held a person in custody beyond the time without taking the steps to expedite the holding of a parade. And this provision exists in law to deal with it. I'm not seeing here and now that an amendment is required, because what it says is that within the time, if an issue arises in an appropriate case, evidence has to be presented to satisfy the court that adequate steps are being taken. So the judge is making inquiries at least once every week into cases of persons listed by the police as being detained with a view to holding an ID parade. In such a case, the court, you have to bring evidence to satisfy the judge that adequate steps are being taken to expedite the holding of the parade. And the judge thereafter may remand the detainee for such further period as is necessary to conduct the ID parade. If not satisfied that it is intended to hold a parade in respect of the detained person within a reasonable time, order that the detained person be brought before the court within 24 hours. Tell me again, and where the person is brought, within that time, the court shall make such order as it considers appropriate. What it is that you were asking to be amended?
Oh, what we were saying is that because the bill stipulates a period of 120 hours, instead of using reasonable time, we could use the same 120 hours.
No, but we have to leave that because the reasonable time may be less than the 120 hours. That's an outer boundary. And in an appropriate case, it is expected that if the parade can be held earlier, if the administrative arrangements can be done, they would be done earlier. And I hope that is the practice. And that was the data. And that's why we didn't see any need to expand the time, because what was presented to us told us of all the improvements that have been made to hold the parade. So the time is an outer limit, you know. So even if it says 48 hours, if you can bring the person within 24, bring them. If the decision can be taken immediately on detention once the necessary processing is done and paperwork, deal with it and do it. And I think from all indications that is where the JCF has moved.
That's the practice.
Right.
Expedite. Those matters are expedited.
Right. So since you are of counsel, Superintendent? Right. So continue to make the point to the police and just remind them. I mean, you know, not everybody is aware of the major changes. There's a big part of the society that is stuck with a view of the police that is not up to date, and that reflects, that is bringing forward all of the concerns, genuine concerns, without properly accounting for the progress made and the improvements done. So, but we will consider, because the committee will have to deliberate on the submissions made. All right, and we will look at it in greater detail.
Thank you so much, Madam Chair. To continue, we want to discuss the release of a surety. And we submit that the provisions of Section 18(2), of Section 18, do not properly address the status of a defendant where a surety has been released from their obligations, either under Section 18(1)A, which allows them to be released by virtue of an application, or Section 18(1)B, where a nolle prosequi is entered in order for the matter against the defendant to either be discontinued in the parish court and be commenced de novo in the Supreme Court. Because there is a gap in dealing with or in treating with what happens after a surety has been discharged, we recommend that the provisions of Section 19(3)B of the current Act be retained in order to treat with these circumstances. And 19.3b states, where a surety is released, the defendant concerned, and A says shall forthwith be notified of such release, but B says may be taken into custody until he provides other surety or sureties. Yes.
Yes.
Madam Chair, so that's section 19.3b that you just quoted.
From the present
that
Act.
contemplates a nolle prosequi situation, or is it an ongoing matter?
It doesn't.
The matter is still before the court, but the surety is released during the proceedings.
A moment. It doesn't contemplate nolle prosequi situations. Hold on.
If I may be able to assist,
Yes.
if I may be able to assist my colleague, the
Just say your name
provisions.
for the record.
Oh, my
Name
apologies.
and
My name is
staff.
Tishana Maxwell. I am a legal officer with the Jamaica Constabulary Force. As it regards the current act, the provisions of Section 18 of the bill are not contemplated. So it just speaks generally to when a surety is released. The Section 18 that is in the new bill contemplates specific situations, and we're saying that the specific situations that are contemplated does not consider what happens, for example, when a surety comes and asks to be released and the judge grants that release, what happens then? So we're just asking for our recommendation is that it should be explicitly stated what happens to a defendant in circumstances such as that, or as it regards a nolle prosequi, because as you know, as a practitioner, when a nolle prosequi is entered, there are several types. So there is a nolle prosequi that can be entered that stops the matter completely in the parish court, or a nolle prosequi is entered where the matter moves on from the parish court and starts anew in the Supreme Court. What happens in those situations?
Counsel, very good points. All right. So yes, please note that we may have to just do a little revision, because you're right, the nolle prosequi can end the prosecution fully, or it may to commence de novo or to move it forward from one stage. In respect of the other, so what the provision contemplates is that where the proceedings against the defendant are brought to an end, then the obligations of the surety are also brought to an end. We do not generally legislate administrative matters. That's why we have regs and so on. But the point you have made, I think we will look at it to see what, if anything, more needs to be put here, and if anything needs to come by way of further clarification. And the point about the nolle prosequi is very well taken. As a good one you have spotted. Right.
Just to say, as it obtains now, let's say, for example, as it obtains now in, for example, committal proceedings, at the end of a committal proceedings, for example, in the parish court, where the accused was on bail in the parish court and the committal proceedings are brought to a close, it is usually the case that the defendant, the accused, has to be rebailed, so to speak, because the proceedings would have ended in the parish court. And I'm just saying to say that, in a parallel sense, if it is that the matter is brought to an end by a nolle prosequi in the parish court, I guess, well, there are different types of nolle prosequi. But if it is that it ends in the parish court and it will be commencing de novo, or it goes to the circuit court, then by operation, well, the consequence is that the accused would have to, of necessity, be rebailed if he was on bail.
You've hit it, counsel. It doesn't mean that the defendant is released. It just means that the obligation of that particular surety comes to an end at that point. It doesn't mean he can't commence afresh again. But we will just look to ensure that the policy intent is clearly captured in how the provision is worded. But you're right, this does not affect the same person even if satisfying the requirements, standing surety again, but at different stages when the obligations may come to an end. Because at the end of a proceedings, a court would normally indicate the status of the defendant, whether they are released, they are discharged, they are remanded in custody, because they may also have other matters pending. So each case has to be dealt with on its own. But I think enough is raised for us to just look back to ensure that we don't have any unintended maladies from the provision. All right? And just to say, Mrs. Brown Blake, that the pages of the Judicature Parish Court Act have been revised so that Section 33A refers to a judge of the parish court and not the magistrate. As the 2021 revised pages, you will pardon me, the Chief Parliamentary Council just reminded me, because it's part of our duty in this ministry to have the laws revised and updated, and it's work in progress. So when we have done them, we have to let it be known. All right?
Indeed.
So the pages have been revised. So you can strike magistrate. This is one of the reforms that though it did not happen in my time, I was the one that recommended that name many, many years ago. Right. Many years ago. Because our magistrate was a special creature, unlike the other jurisdiction. But just to know, those pages have been revised. 2021 revised pages.
We stand guided. We will ensure to download a more up-to-date copy.
Yes, all right.
But not to stray from the point on surety, you mentioned that, we don't practice to legislate administrative matters, but just to point back at 19.3 of the current legislation, I think a carryover of that provision would be useful. It's in our submissions. I quoted it in the submissions.
Yes. I can see the wisdom of the recommendation.
Grateful. All right, we're on the last lap. Now on to our further recommendations. We take this opportunity to make the following additional proposals. Now, a small one, but we thought that the term vary should be defined in the bill. The current legislation has a definition, and we recommended that it be carried over with a very minor change, and we outlined it here. The language is used in the Act, and so we thought that it should be defined. Just a small recommendation. When
we come to deliberate, I usually defer to the CPC because there are rules of interpretation, and where a word is not given a technical meaning, then the ordinary grammatical, it's taken in its ordinary grammatical context. Meaning in context. So I will defer to the CPC on that, as to whether it's necessary. But I don't know that it would be fair to define vary to mean imposing further conditions, because a variation could also mean relieving the defendant of the burden of a condition in an appropriate case?
Well, it's an or, so we have, so the current legislation, it uses this definition only with a minor change. It says imposing further conditions after bail is granted, and then we had or changing conditions imposed in relation to the grant of bail. So the current legislation, the definition is very similar. It says imposing further conditions after bail is granted, or varying or revoking conditions imposed in relation to the grant of bail. But as I said, this submission is very minor, and of course, I await the decision of the CPC on that matter. But we move to another further recommendation. I want to move to 3, where I have III. Section 59D requires a defendant who has been granted bail to inform the officer in charge of the nearest...
So you're not pressing the submission about breach of the condition to be an offense?
I am.
No, man, we provide for revocation of the bail in those circumstances.
Right, and we understand that.
You know, I don't believe in overly criminalizing people, you know. Although I know that consequences must flow. Right?
I understand. I take your point, you know, but why we included this is because seeing the practice in the courts, many judges do not wish to revoke bail, and they deem such a revocation to be excessive. So they'll use terms like, well, you breach and we should revoke, but, and they don't go on to revoke bail. If we had the statistics on revocation, they may come out very low because it is most often deemed to be too excessive.
Is it provided for in the way that it is now provided for in the current bail law? Remember that as legislators.
In a similar form. It is not exactly the same,
Right.
but I think the form is similar. And they use language like, you should be penalized because you did such an action, but we will just readmit, or something similar. And unfortunately, revocation is infrequently practiced. So that is why we made such as a suggestion here, or submission here, for there to be an offense.
You know that that's why you have reviews and appeals, eh? If a judge errs. So we may disagree with the exercise of judicial discretion, but it doesn't mean that it is wrong because we hold another view of it. Because every matter turns on its own circumstances, and the judge is best placed to determine based on what is presented to it. Very often, the conversation in the public space is devoid of the specific details of what went before the court. And that is why we have been so careful to get the data and get the evidence in developing the policy. All right? You know, you would have been here earlier when the president of the Jambar debunked the view that people are granted bail left, right, and center on murder. Though we do have very bad examples of accused persons charged with murder being on bail and are brought back before the court or are being investigated for the commission of other offenses. So it's really striking the right balance. The jurisdiction has been very nervous about tinkering too far with the exercise of judicial discretion. And the lesson we have learned from the case law that we have read, we have to trust our institutions, notwithstanding the problems that we have. And it is not the best approach to tinker too much with the judicial discretion. So you guide the exercise of it statutorily by saying to the court, these are matters that you should take into account. And based on what is presented, if you properly take them into account, then your decision should go in a particular way. But you would see one side, but as legislators, we have to strike a balance that brings fairness to both sides of a case, the Crown and the defense. So not that I'm dismissing it, because this process here is not that we're deciding, but we're receiving your submission and exchanging perspectives on it. But I would have to be persuaded a little more on that, because so far the argument is unconvincing.
Understood. I hope, though, that the opportunity to have this point rediscussed or discussed again in another forum remains, because the practice that we see is for readmittance instead of revocation.
You know that we have become an expert in solving the wrong problem in this country. Many times we identify, but we fail to deal with it because we either can't be bothered with the process that is involved. And to my mind, you know, the formal justice system is a rules-based system. And process is at the heart of the justice, the due process, and also other procedural matters, substantive and procedural matters. And we have gotten to the place where we can't bother. It's such an instantaneous expectation that because things have taken long and are frustrating us, we shouldn't be bothered with the process. But you don't get justice without procedural propriety either. That's why, on a technicality, someone can be acquitted, though very much guilty of committing the offense. So we have to be very careful, and especially attorneys. We have to get a deeper understanding of the proper functioning of the criminal justice system. We do not have the luxury, and I say we, including the JCF as an important department of the state, through the Ministry of National Security, in getting caught up just with the emotions, you know, because of a wrong that may be perceived. The burden of proof is a heavy one. The standard of proof is a high one. And when someone is accused of committing an offense, there can be no shortcut in doing the work to meet the standard of proof beyond reasonable doubt. So, yes, there may be concerns about how the judges exercise their discretion that leave us with real concern. But you know that if the exercise of discretion is wrongly done, there is appeal. That's really the short answer through the long run-up. And we who are members of the formal justice system is not just the courts, police are part of it, must never get weary or want to shortcut procedural propriety. Too many lessons to learn to make the same errors of the past.
Thanks, Madam Chair. Just a moment.
Assured that the further submissions will be considered because there is merit to some. It's a committee that decides, not just the chairman.
Okay. Just want to inform the committee that the police have been practicing some level of pre-charge bail, particularly in fraud investigations before the consideration of this bill.
You want to tell them that it's provided for in the Constabulary Force Act, because many people think it's new to the jurisdiction, so pull it out. I don't ready to drop it on them yet. Right.
So you have like some complex fraud investigations that on the face of it, this suspect, you have a suspect, but you're going to have to order that an audit be done and to request court documents, and these things take time. So usually the defense attorney and the investigators reach some level of agreement, and the persons are allowed to remain before not charge until we reach some distance in the investigation. So we have been practicing some level of pre-charge bail.
And those defendants are happy.
Are very happy.
Are very happy that.
Are very happy that we approach it that way.
So, Superintendent, one of the reasons why we had to clarify that arrest includes apprehension, if you look in the definition section of the bill, you'd see the first clause 2, arrest includes apprehended, arrested includes apprehended. It is precisely because, just to put beyond doubt and reconcile the provisions of the Constabulary Force Act, where the pre-charge provision is. And also it appears in less clear terms in the current law in the definition of bail in criminal proceedings. It's just that it was not fleshed out.
Very well.
But you see, a lot of people don't read the details. And to say that on this issue, because that was also brought to us in the policy formation stage, is that notwithstanding the hue and cry, there are many who understand that the ends of justice are served with such a provision, especially in those matters. And remember, fraud now is one of the scheduled matters for money laundering.
That is true.
Right.
And based on that practice, we are asking that the JP or the constable be allowed to ask I don't want to use defendant, the suspect, to surrender his or her travel documents, because that is something they normally willing to do while we are investigating. It's not currently in the bill.
We considered it a lot, and it was along the line of impairing the right to freedom of movement only to the extent that is necessary. So it is true that it is part of our law that the surrender of travel documents is a condition of bail. We deliberated on it behind the scenes and thought that that condition would be better imposed by the judge under any other condition deemed appropriate instead of giving it to the police or the JP. But we can look back at it because in an appropriate case, I think sometimes people don't understand the kind of offenses and the kind of circumstances. That's why every case is best dealt with on its own merits and it's in its own circumstances. But remember, you do have another accepted way of dealing with the risk of flight.
That is so,
right,
Madam Chairperson. That is so.
Which is used a lot in the jurisdiction and is used a lot in international policing. All right?
That is so.
And you should know more than I do. I only know it from the court's side. And I don't know of a case where that method was successfully challenged. I don't know of a case.
No, it's very effective.
There you go. There you go. Yes.
Okay, as we press along, we are requesting that the committee consider expressly authorizing the police to visit persons who are subject to curfew orders. Why we are asking this? We are aware that there is electronic monitoring in the bill. However, currently when we visit persons on curfew orders, especially the violence producers that we visit during the crime band periods, the defense attorneys will make submissions before the court to say that we are harassing their clients and we have no legal basis in law to be visiting upon the addresses of their clients to check if they are there. So we would want the committee to consider giving us that authority to check on those persons on curfew orders, especially those that are not wearing electronic monitoring.
So this morning, a concern was raised about cost incurred by persons to visit police station. Maybe we can consider it as a flip side of relieving them of the cost and the police going to check on them.
But the curfew order is saying that they are to remain in their home at between a certain time, so We want to ensure they're there.
So one thing that legislation going forward must be based on proper data, proper evidence. The policy must be sound. Are you saying that submissions have been successfully made, or just noise submission, that there is no basis? Because the police really, I mean, the rights are guaranteed, and I know the police are getting training in human rights. If someone is under investigation, the police can go. I don't think there is, the privacy of the home and family life is guaranteed. It doesn't mean that you can't go, but there is a certain process that has to be used. I don't know if the complaint is so much about the fact of it being done or how it is done when it is done by some officers.
Well, some judges will agree to say that we are to stop harassing these defendants. We have no basis in law to be going and checking on them.
All right.
Madam Chair.
Yes, Senator Sinclair.
I'm listening to the superintendent. But from what I see happening in court where the complaint comes is the manner in which the police makes their checks when a person is on bail with a curfew order. The complaints that come regularly, I don't think the person who is under the curfew order ever has an issue in the police checking. One would expect that they would check because to verify that they are complying with the order that is made. It is the manner in which it is done. And some person, the police goes at 2 o'clock in the morning, 3 o'clock in the morning with sirens blaring, loud horns and banging on the gate and so forth. Some persons reside in premises with landlords. Persons have been asked to leave premises because of the manner in which the police approaches it. And that is the complaint that generally comes to the court in respect to what the situation the superintendent has raised. I don't think that there's any complaint about them doing their duty, but I mean, there's a way of approaching it. And I think that I wouldn't want to see it legislated that the police should go and do it. I'm certain that it is implicit in an order that checks can be made to verify that the person is really complying with the order. But as I said,
from the
over the years, the complaint has been the manner in which they have approached it.
My question, Senator Sinclair, as to
yes,
whether that is so or it is a fact of it being done. Let me hear the response from the SUP.
Yes, we wouldn't normally go with siren blaring because we would actually want to go there and don't find the person there so we can have that person's bail revoked.
I don't think that is what your intention could actually be. You would prefer to go there and
no,
the
intention would be to go there in a discreet manner.
Discreet. We wouldn't be going there.
I'm telling you, Superintendent, I have been in the system, the court system, for quite a while. And that is the complaint that you get from defendants. In fact, as I said, I have had clients who have been asked to leave the premises because of the disturbance caused by the police when they are making a check. The individual is there. Sometimes persons sit and wait until the police comes to check and to sign their book and then go to the bed. But sometimes the police turns up 3 o'clock in the morning for that.
Practical
perspective.
I get the point.
I can't have you in my premises and this disturbance is taking place, which is also impacting me in the quiet use and enjoyment of my property.
I get your point, Senator.
I don't know if Member Williams is there. He may be in the court. He can express what he has seen as his or heard in respect to cases involving curfew orders.
I tend Through Madam Chair, I tend to agree with Member Member Sinclair, sorry, in respect of his formally, how he puts it, because I don't think accused persons do have a problem with the officers based on my experience checking on them, because it's done a lot, Madam Chair, it's done a lot. But sometimes it's the manner in which it is done. You know, and there are times when, obviously, some of these accused persons, I do agree, don't live up by themselves, you know, and they live in a context with others. And then there are sometimes, in my experience, there are times when, you know, there is this presumption against the person. And we do have situations where, you know, persons, and I say it advisedly, and, you know, it must be contextualized. I've seen situations where, you know, officers get personal, and because of their personal issues, you know, they approach to check the monitoring in a particular way. So I don't think there's a problem per se with checking on the accused. In my experience, it is really the manner in which it is done, or the frequency or regularity could border on intimidation or harassment in some circumstances. Because if you check on a person 7 o'clock, and then, you know, the curfew is between 6 and 6 in the morning, you check 7, the fellow is there, and you go back 8 o'clock, and you go back 10 o'clock, then, you know, in those circumstances, it becomes a little harassing. And I've seen that happen.
Before the superintendent respond, there's another harsh reality in the jurisdiction where, in some cases, any approach by the police, however courteous, however professional, is viewed as harassment. And the data that we're monitoring show that short windows are used to commit horrible crimes. You know, so even, I think the crime ban is at 2 a.m. Yes.
6 p.m. to 12 midnight, and
Right.
that's the time
That's
we
the
usually
data. Right. So
check on these persons.
So again, what people don't know is that we actually are using data in terms of the report when we are formulating this policy and the revision of it. But just to say that I think there is merit on both sides. Many times, superintendent, the police high command agree on the standard, but a particular constable out in the field may deviate from that standard. What is going to be critical is for the officer to be able to explain properly, cogently, and truthfully what he or she has met upon in the discharge of the duties. And I think sometimes that is where there is a falling short. So when we're doing the training on the Firearms Act recently, the learned Chief Justice made a recommendation that the police must get back to the point of carrying their notebook, writing it down. He cited the example of a former police whose credibility was so well respected because he documented that it almost became difficult for people to challenge him. So we are working in a context of broken trust and trying to rebuild the trust. And, you know, unfortunately, as an institution, the JCF has had a very bad reputation. And many are still not taking sufficient account of the positive changes made. But there is another thing. The place to spot a fault is where it occurs. And that is why the point made by Tony Lors, who described himself as just an ordinary citizen, becomes even more important. When appropriate action is not taken against an errant officer, the institution becomes tainted. And going forward, where the exercise of the power is not done lawfully, those persons on an individual basis have to be addressed. And it is not compromising their zest and zeal, but is recognizing that the police are not entitled to break the law in their efforts to have the law upheld. But I think we're on the right path. It's going to take time to really rebuild the trust to the extent where the police is going to be given the benefit of the doubt. And context matters. But just to say that the ask that you have made can be achieved with a minor tweak, because the judge can make such an order in an appropriate case where the imposition of a curfew order is made as a condition of the bail at that time. So perhaps if we look at where we say where the deciding official is the court, such other conditions, it could be, or orders as appear to the court to be necessary without really legislating it, and for each case to be dealt with on its own merit.
That's true, Madam Chair, because if we have a breaker who normally breaks between 3 a.m. to 4 a.m., we would want to visit that person at that time of the night, of the morning.
Right, and I would remind you again that, so when we talk about peculiarities in Jamaican context, you know, people don't understand or deliberately are shutting their eyes to the harsh realities. Those of us who are elected representatives, we see a lot in the constituencies, a lot. And we have some senators who are also elected in the local government, like Senator Charles. We see a lot. So a lot of the harsh realities do not escape our glare at all. And we have to bring that experience to bear when we are passing laws in our legislative role for peace, order, and good government. So I think there is merit on both sides, but the goal at the end of the day is to ensure that the police can do the proper monitoring to further the aims of justice. And I think with a slight tweaking, we do not have to provide for it in the way you have asked for it, but we can leave it to the court where once that condition is imposed, a request can be made. So we can do the tweaking.
Very well, very well.
All right.
We also...
Remember, we have Miss...
Yes, we are
Golding,
wrapping up.
and we're going to hold you to listen to Miss Golding.
Yes, we're wrapping up, ma'am. The electronic monitoring.
Yes.
I'm not sure if the committee looked to the current legislation as to malicious destruction of property to address it, but we are submitting that if persons defendants should destroy it or attempt to manipulate it, it should be specifically provided for in terms of penalty.
The wisdom of that submission is obvious. The wisdom of your recommendation is obvious.
Note very well, madam. Section 24 of the Act, which makes consequential amendments to other enactments, we ask that the Corrections Act be amended in Section 2, subsection 1, so that the definition of correctional institution can include a place of detention and lockups. What we find, Madam Chairperson, is that persons quite frequently try to introduce marijuana, cell phones, knives into our lockups, and we have no legislation to charge them for. We are normally told that it's provided for in the Corrections Act, but lockups do not form part of that definition. So we are submitting that we could...
I'm sure we looked at the lockup in respect of the judge, the power of the judge to... But is it a proper matter for the bail bill? Because the entire corrections, the legislation around the correction institution is under review right now. So if you have not yet made your submission to your parent ministry, please do so. All right? But we'll note it because it is important that we understand that the whole of the justice system have to come, the entire system has to come together at a certain point to get the positive results that we're seeking. Right? I will note it and ask the team, we'll consider where we put on the issues. The issue is, well, he has identified the Corrections Act as the one to be amended. The only question is whether this process of passing a new bail law is a proper avenue to use it for consequential amendment. But we look at it behind the scene because part of the ministry's work is also to take the recommendations and the concerns raised which require legislative solution and ensure that where appropriate they are carried through.
Very well. Lastly, we are asking that an offense be created for persons who are arrested and detained who provide false information to the police in terms of name, age, address, occupation, and the like. We realize that the surety, if the surety makes a false statement, they can be charged. If the person who is making a declaration as to the surety's identity and the surety's good character, that person can be charged. The only time the defendant will be able to be charged for making a false declaration if he is bailing himself. But giving a false name and address, date of birth is no offense, and we see that as an issue. If the person is not granted bail and is in our custody with a wrong name, the possibility exists for the person to be released, and that person may be wanted for serious crimes. So we believe the defendant, a person arrested or detained, must give their correct name and address, and if they don't, there should be an offense created there.
All right. This is one that will have to be put to the committee for serious consideration. Like I say, my default view is not to over-criminalize our population. I think already we have too many offenses on the book with a low enforcement rate. But at the heart of the criminal justice system, and in particular the formal prosecution of cases, is proof that the person before the court is a person that committed the offense. So from my own experience at the public bar and on the bench, and even in this role, I understand the wisdom of the submission. My only reticence and slowness is because we have taken great care not to create too many offenses in the process. But I recognize that at the end of the day, the person may be acquitted, and not necessarily because the person did not commit to the act, but for any of many reasons where there is failure to meet the standard of proof beyond reasonable doubt. So there may be a place for it, since issues of identity are so critical in the investigation of a matter. I'm not seeing many members of the committee still online, but this is one that I certainly would want to hear some exchange of views on. So
Very well.
I totally understand it. I totally understand it. All right.
Better to know their name than the person himself. You criminalize the surety.
You know, Superintendent Bailey, boy, there's just so many grievance points in the society that even when you're trying to do things in the best interest of persons, they are so suspicious of it. You know, even matters around just a probative value as opposed to the prejudicial effect of material. So it means that our work is cut out for us in no mean order. And I'm going to count on you and your team to ensure that the better approach is consistently raised and reiterated among your colleagues.
Very well.
In this context where we are all prisoners in our own homes with this unhealthily high rate of crime. You know, so, but I understand, I really understand, and it's going to, the burden falls on us to hold our ground and explain, because the suspicion is that automatically is to bring further injustice. And we have to be always careful about what problem we're seeking to solve and why.
Very well, my lady.
All right. So we thank you so much to the JCF team. I think,
you're most welcome, madam.
You have not really merely repeated issues raised, but I think every point, whether preliminarily I agree or not, I think you have made very good points for consideration by the committee. And I want to thank you.
Grateful.
Grateful.
So I'm going to ask you to sit and listen to
We will.
Miss Golden. Miss Golden, please be as succinct as possible, because we have had a long day, but I don't want to cut you off. And I also, well, please introduce yourself.
Madam Chairperson and members of the Joint Select Committee on the Bail Act, good afternoon. My name is Shemail Golding. Having studied political science and criminology and law, I have a keen interest in the happenings of the state. I am currently an assistant lecturer at the Knox Community College, where I specialize in teaching law. My past experience includes working at the Corporate Area Resident Magistrates Court, as it then was, and at the St. Catherine Parish Court, where I carried out paralegal functions. So thank you for inviting me to share what I deem as my assessment of the current bill, the Bail Act 2022. In perusing the memorandum of objects and reasons addended to the current bill, it was evident that the rationale behind the current bill is to balance the aims of justice to the victims of crime with the rights of the accused, all in line with the Charter of Fundamental Rights and Freedoms, and to add, in my estimation, Jamaica's international obligations within the harsh context of Jamaica's crime scene. Thus, my assessment was aimed at finding the right balance between these competing interests. At the outset, I'd like to say that life is filled with many positives and negatives, like the light switch and like the car battery. So too, with this bill, thus taking all other provisions equal, here are my recommendations. Regarding the interpretation section, which is section 2, although it is understood that there must be a catch-all phrase to exclude certain categories of persons from being deemed as defendants for the purpose of the Bail Act, it is suggested that in terms of the definition that you have of defendant, in terms of that section where the Act states failure to do or abstain from doing anything required to be done or left undone, in my estimation, that part of it is a bit vague, and further detail could be given, such as to say possibly in civil law, or as the case may be, that something in that sense could be added to the definition of defendant. Furthermore, in section 5.7 of the bill, reference was made to varying bail, but for the untrained eye, it may be unclear what is meant. Hence, a definition, namely that found in the preceding act, may also be used in this bill.
You and the JCF are on the same page with this recommendation.
Correct. The same goes for the definitions of surrendering into custody and bail in criminal proceedings used in the previous Bail Act. It could be used in the present bill, notwithstanding the fact that the word defendant in the interpretation section of the 2022 bill reflects some of the provisions reflected in the term bail in criminal proceedings found in the Bail Act 2000. My recommendations for Section 2 are under the guise that untrained eyes, including especially high school students, have reason to interact with legislation, thus making some terms particularly clear for them will help in their interpretation of the Act also. Furthermore, though Section 3 stipulates that the Act applies to the grant of bail to a defendant, because the term defendant is also used in civil proceedings for young persons just learning the law, it is suggested that it is important for them to understand that bail only exists in criminal proceedings through the exposition of the term in the interpretation section. onto grant of bail prior to charge, which is section.
I can see your teaching experience informing the submission. I can see that. But I also make an immediate link with the importance of members of the society understanding the law.
Yes.
Yes.
Okay. Thank you. Grant of bail prior to charge, which speaks to section 5, subsection 3, which states that prior to charge, an accused may be held in custody for 120 hours to await an identification parade. It is suggested that it infringes the accused person's right to be given reasons for his arrest or detention, to be informed forthwith of the nature of the charge, to be brought forthwith or as soon as is reasonably practicable before an officer authorized by law or court, or to be released either unconditionally or upon reasonable conditions. All those provisions are found in the Constitution, sections 13 and 14.
That you're of the view that it breaches those?
Yes, it could. No, it could.
Oh,
it could in the event that the person is detained for the 120 hours. As my submission is that 120 hours is too long a period for the person to be detained without charge pending an identification parade.
Isn't that what currently obtains?
I understand that it may be
Right.
what currently obtains, but if it is done in practice, it doesn't necessarily mean that it is not without fault constitutionally.
But remember, the purpose of the parade is to ensure that the right person is charged.
Yes.
Right. And there is quite a bit of case law around it. But I think the way you have raised it underscores something that I've said before.
Yes.
That such great care has to be taken in how we draft not only ordinary bills, but even the provisions of the Constitution. Because where a derogation is accepted as demonstrably justified, to the extent that you provides for it outright, we have to ensure that we do not have unintended consequences of interpretation because of how the language is used.
Okay.
Right. So, you see, because you don't want to compromise the identity of the person or create opportunities where it can be properly said that the person has been exposed, you have to be very careful where the suspect has to be identified in order for the charge to be preferred against him.
And while I accept your point, this is just the issue of the time period. So it's not about the fact that the person has to be held or detained to go through an ID parade. That is not an issue that I have, but it is just the time period.
Robinson against the DPP and the AG, an old case which speaks to what amounts to reasonable time.
Okay.
If you haven't looked at it recently, I commend it to you for your reading. Judgment of the Privy Council. Out of this jurisdiction.
Okay, then. Thank you. All right. Therefore, what Section 5.3's provision would cause is an infringement of, I'm just continuing, is an infringement of various constitutional provisions which mirror the same provisions in the International Covenant on Civil and Political Rights, which Jamaica has ratified. Thus, 5 days imprisonment pending an ID parade, which may or may not result in a charge, may open a floodgate of habeas corpus, false imprisonment, and applications for redress claims in our courts, which fosters further challenges that may arise from these applications being made in our courts. Conditions of
Some submissions have raised a concern as to whether this will impact the grant of habeas corpus. I think it will make it easier to get the outcome that you want, to ensure that persons are not improperly held in custody,
yes,
where they should not be or for longer than they should be.
Okay.
Right. And I think one of the earlier presenters responded, I think it was Mr. Williams from the Jam Bar, which gave a different view, which to my mind represents a better view on the matter of habeas corpus applications in respect of the provision and how they interact.
Very well. Right. Conditions of bail being Section 8. It is acknowledged that improvements were made in this section vis-à-vis the Bail Act 2000, including the use of electronic tracking devices. It is suggested, however, that in keeping with Jamaica's obligation under Article 10.3 of the ICCPR to have a penitentiary system where the essential aim of treatment of prisoners is their reformation and social rehabilitation, and in an aim to address circumstances peculiar to Jamaica as stated in the bill's memorandum of objects and reasons, and to address the issue of recidivism, which is an issue that plagues our society, mandatory counseling for repeat offenders could be introduced as a conditional bail condition as the judge, in cases as the judge sees fit.
Counseling as a condition of bail?
Yes, mandatory counseling for repeat offenders.
Well, there is the provision, no, such other condition as the court thinks appropriate. It would have to be one of those made. So two things is that we specify as a way to signal.
Yes.
Right? But then when we give the wider provision, then it is open to the court in the appropriate case, in the circumstances, if it believes it right to do so, to make such an order. So as is provided for, there is, such a submission could be made to the judge.
Yes.
I'd be interested in hearing how it is received. But I always listen very keenly to innovative suggestions within the criminal justice system, because the research I've looked at shows that many of the bold suggestions that are not usually taken on are the ones that could really help in a real way. And in some jurisdictions where they have been taken on, they have been defunded because people don't understand that you have to stay with them to get the outcome. You know, it's the adaptive cultural issues that they are addressing, and we're so caught up with the technical fix that we don't have the patience to wait it out. So, interesting.
Yes, I understand that the catch-all phrase is there so that other conditions could be included, but because it is not necessarily something that is done in practice, and because of the work that the Ministry of Justice is currently doing in terms of victim services and counseling, and especially restorative justice, I believe that if it is included as a specific provision, that will garner judges to actually utilize mandatory counseling instead of waiting on it to be requested then by counsel. So I think that it would be more effective if it is legislated.
I warm to the idea. Okay. Like I say, this is not a decision-making exchange, but I certainly understand where you're coming from, and I can see the thinking outside of the box. Perhaps, again, because you would have interacted with so many young people as a lecturer.
Yes.
But I understand where you're coming from.
Very well.
Yes.
Okay. Recording and giving information on decision concerning bail. It is hereby suggested that in Section 10.1, the word surety be included in the list of persons to whom the record of the decision is to be given, especially if the prescribed form that is being referred to in this section is the bail bond, since especially at the parish court level, the surety in practice does receive a copy of the bail bond. Review of bail decisions. Section 11.3 is forward-thinking, especially in the provision about a list of defendants who are unable to take up bail being provided to the court on Monday of each week, because in the past such persons would get lost in the system, some of which would only be uncovered when judges went on remand or jail delivery. So I must make commendations or say kudos to the drafters who have addressed this issue in such a way.
Just to say that the policy behind it came out of very practical experience I had while I was a judge of the parish court.
Yes.
And again, this is where experience and understanding of the wider justice system can help inform policy.
Yes.
But I used to do remand.
Yes.
And initially I thought that it had been formally provided for. Now we know that in the Parish Court Act, the presentation of evidence around the ID parade came in a 94 amendment and I think included in a 96 revision of the law. But this one, to my mind, represents the right thing to be put in the statute so that we have no one lost in custody. And it has to be done routinely. And you'd have seen we have made provision for who should supply the list at all levels of the correction system. Since the superintendent is listening, you'd have seen there that we included the lockups in this provision because we took into account the shortfalls in the Corrections Act, which you were asking to be included in the amendment. So my heart is warm to hear your feedback on this because it came out of direct experience during my time on the bench.
Understood.
Yes.
Absconding by person released on bail. It is foreseen from my perspective that reference to reasonable excuse in relation to Section 14.2 could pose problems in terms of statutory interpretation in relation to what constitutes reasonable. Therefore, whether in this bill or with associated regulations, it is suggested that particular parameters be included for interpretation, especially as to whether, due to the fact that the defendant would not yet have been charged, possibly the interpretation that could be given of reasonable. I'm not certain if the interpretation would be objective or subjective in that context, and so possibly some parameters could be set forth as to what exactly could constitute a reasonable excuse for absconding or failing to surrender to custody.
You are a critical thinker because I find it a better approach to always help to guide the exercise of discretion. Yes. And you're right that although we do have case law for guidance on this matter, it may always be helpful to kind of guide, signpost.
Yes.
So subject to the deliberations, I do welcome it. Sometimes we have to leave the matters as broadly to ensure that the court and the judge who is best positioned to assess the case in its own circumstances is not unduly restricted. But you're absolutely right. You're absolutely right that some guidance can help without taking it too wide or too narrow, but just to give some direction.
Thank you.
Yeah.
Bail with surety. Section 16.2 referred to the fourth schedule under the heading persons exempt from acting as a surety. However, the first listing is
misprint, error.
Okay, very well.
Yes. That's a printing error.
Very
because murder is not a person exempt; it's an offense.
Right.
We picked it up, unfortunately. Okay, no, you are very keen because we picked it up, but nobody else has listed it. So it tells me just how sharp you're focusing in your analysis, teacher.
Thank you very much. Okay, and lastly, a general recommendation. Now, Section 14, subsection 2B of the bill makes reference to a document which shall be evidence of the time and place appointed for the defendant to surrender to custody. Most importantly, since this is done in practice, mention could be made of the accused who have been granted bail, who have reporting as a condition to keep a bail book. It is done in practice where they get an exercise book and it is to be signed by the police.
Say you serve as a clerk in the parish court?
As a paralegal, assistant clerk.
I see. That's before becoming an attorney?
I'm not an attorney.
Oh, you're not an attorney?
No, I studied law, but I am not an attorney.
I see. I see. Because only a practitioner's perspective would have captured this one. I mean, who understand the nitty-gritties behind the scene. Commendation again.
Thank you.
Because it is done in practice.
Yes.
Yes.
Yes. So, so the accused person could keep a bail book which shall be signed by. It is my recommendation that the accused person keep a bail book which shall be signed by a police officer upon reporting. So, in this sense, the bail book may be included in this section as further evidence of whether the defendant has failed to surrender to custody. And those are my submissions. Thank you very much for listening.
Well, well, well. Let me just find out if any member has any comment or question. No, we're coming to the end of the proceedings. All right, until I see a hand raised, I really want to thank you.
Thank you.
Today has been a good day. The police want to make a comment on that? Yes.
No, I wanted to inform her that the book is in place now. They have a book that
she knows it, but what she's asking for is to include it as part of the prescribed record.
Okay, to make it official.
Absolutely. Yes. I mean, it's a genius recommendation to my mind, because it wouldn't take much to include the form, but which means, Superintendent Bailey, that you would have to get us that form, get us in the format, so that when we come to consider it. But yes.
Very well.
What a day it has been. Miss Golden, let me thank you for taking the time to, when I received the presentation, because it came early.
Yes.
I inquired whether it was Senator Golding, Shireen Golding, because I saw the S. And I sent her a note to ask if she were responsible for the submission, because they were obviously very learned submission, to my mind.
Yes.
But she said it wasn't. So I was actually looking forward to meeting the Miss Golding behind the submission. Like I say, I don't take the decisions of the committee, but I am the minister with carriage of the bill and do have a special place. I want to thank you. You have truly acquitted yourself well. And I think your students are blessed to have you guiding them.
Thank you very much,
Yes.
Minister.
May I also say thank you to both of you, both of the submissions. I know it's been a very long day, but it was definitely worth the wait. I was dying to hear your presentation because you had such a colored copy. And to hear you speak, it was very good because, you know, I am not an attorney, and I think that you were so clear, like a 4-year-old could really understand. So I do want to say commendations to you. Thank you.
Thank you.
And I think the police have also been very helpful. Helpful at different stage, but I also, I'm grateful for the submissions made because I understand the practicality of them. Yes. And
Yes.
I know you had to pull back the first set of submission that you were going to put forward. Don't think I don't know behind the scenes. Yes.
I know you're not considering creating an offense for conditions imposed by the JP and the constable for pre-charge bail. But I would like the committee to consider something some obligation, even if it's something that the court will look at adversely if the person is eventually charged. But there must be some level of consequence for not complying with it.
Superintendent, I come to this process with an open mind. I have said to colleagues who are members of the committee that the policy underlying the review of this Bail Act is well thought out, even if we end up disagreeing and we take different views. And I found it quite instructive that those who have presented so far and have espoused the view that the pre-charge bail regime is unconstitutional cite the same Section 14 that we have cited, some of the cases we have looked at, and I think only the UWI so far has presented a view which aligns with the path that we're on, even though they did not go as far as saying it. But certainly their submission was not that the regime was not good. So I really do believe that part of the solution to getting to a more lawful society is to have laws that the people own. And the laws have to be fair. Some laws have struck an improper balance, as it were. But in a wider context, you know, this legislature has an important history. Because there was a time as a legislative assembly when it was used to pass laws that oppressed the people, that represented the interest of a class that did not see equality as important. And so I come to the role very mindful of that. And I do feel very strongly that when we have to take strong measures, they are justified. But even in taking that, the process has to be fair. Because we are operating in a Jamaica where many want their wrong to be adjudged right. There is much impunity. But today has been a good day because I think the submissions by and large have been of good quality, even if we disagree. I have expressed my disappointment that with the guidance provided by the court as to the approach we must take in adjudging whether a derogation is permissible, I've seen that nuanced approach absent from some of the submissions from the lawyers that come. But that aside, I think it's a good day today. And I'm particularly grateful for the members of the society, including Ms. Golding, Mr. Luars, who came outside of the institutions and the organization to make their contribution. You can go away, Ms. Golding, with a good feeling, because I believe the time you have taken to read the Act and make your submissions was worth the while, certainly from my perspective as chair of the committee. And I want to wish you well as you guide the young minds in the teaching of the law. And certainly, if I can be of any assistance to you in any way, or any of us, do not hesitate to let us know. Mind you, your submission will be deliberated upon by the wider committee, and then we will decide what is accepted or what isn't in the normal process of dealing with submissions before a joint select committee. But I really want to thank you for taking the time. If you want to have a conversation afterwards, you can hang on while we conclude.
Okay, then. Thank you very much.
All right. So I think that takes us to the end of the formal proceedings. And the next item on the agenda, we would have done all but one of the listed presentations for the Independent Council of Human Rights, and we will set that for the next date, the next sitting of the committee. So let me just ask, is there any other business? Right, the other business then is a date and time of the next meeting, and that's Tuesday, December 13 at 10 a.m. We will take the submission of the Independent Jamaica Council for Human Rights. There is one other submission that came in from a Jordan Jarrett, albeit late, Mr. Jarrett. We will take it, but we really have to cut off. And then we will deal with the issue of the minutes. So the time between now and Tuesday, please ensure that the minutes of the last meeting and today's meeting are available for review. And after that, we will go into the clause-by-clause deliberation against the submissions made. Further meeting dates will be Wednesday, December 14, 10 a.m., Thursday, December 15. So Tuesday, we will take the remaining submissions, deal with the minutes. We won't have a long sitting because we have the Parliament in the afternoon. And then for Wednesday and Thursday, we will begin the clause-by-clause review of the matter. All right, just dealing with the meeting formalities. Unless there is anything to be raised by anyone, will someone move for the adjournment of the meeting? Thank you, Member Charles. Seconded? Member Sinclair?
Member.
Hi, Madam Chair. I was looking at something.
All right.
What was the query, Madam Chair?
Seconding the motion for adjournment.
Yes, I'll second the.
All right,
Thank
so
you.
date and time of next meeting, Tuesday, December 13, as previously agreed, 10 a.m. Meeting is adjourned at 4:30.
Over 100 homes delivered across 14 parishes. Your government, under the new social housing program, is making home ownership possible for those who didn't even dare to dream. Over the next 3 years, we will be building 1,500 homes just for our vulnerable citizens. Without a doubt, all citizens, irrespective of economic status, deserve a good home. Your government cares.
The proceeding was brought to you by the Office of the Prime Minister,